All right, good morning and welcome to the University of Illinois College of Law. My name is Melissa Friedman. I am a clinical professor here and also the director of our Family Advocacy Clinic. Welcome to those folks who are on the webcast as well. Please let us know if you can't see or hear us clearly. We're really happy to be able to host today's next in a series of trainings that the Illinois Parent Attorney Network is putting on. Today's training is our first foray outside of the Chicagoland area, and our focus today is really on trying to reach out to folks around the state to particularly bring some of the training downstate, because all of the trainings have been up near Chicago, and to reach out to folks who might be a little bit newer to the hard work of representing parents in child welfare cases. We also hope that what we have lined up for you today to discuss the kind of basics of juvenile court orders and evidence, as well as the kind of shadow process of administrative proceedings, will be helpful not just to those of you who are new to this area of practice, but to all of us who could use a refresher on the complicated Juvenile Court Act and its ever-changing dimensions. Before we get started with today's training, I'll note that there will be many more future Illinois Parent Attorney Network trainings coming up that I hope all of you will join us for either in person or over the webcast. We don't have an exact next date for a training, but there is a training in the works coming in the fall in Chicago. It's going to be on working with clients in mental health issues in the child welfare cases in the child welfare system. But for now, let's focus on our plan for today. We have two phenomenal presenters who are kind enough to give of their time and knowledge to be with all of us today. We have Louis Mallow and Alan Novick. Alan isn't here yet because he's still in court in Bloomington, but he'll be joining us this afternoon. But first, taking us through the morning and into the afternoon is Louis Mallow. Louis, I'd say, is our resident trainer-in-chief for IPAN, having presented at many trainings before. He's undoubtedly an expert in child welfare and an amazing defender of parents practicing in Peoria. He has his own law firm as well as acting as a public defender. He's published and provided trainings of this kind all around the state, and he will soon be bringing his training to the ABA National Conference in Washington, D.C. He has many appellate and Illinois Supreme Court victories under his belt, so he knows in great detail exactly what he'll be talking about, and he has a lot of information to share with us today. As you can see from the materials that you have, he's amassed an amazing tome on evidentiary issues and is now tackling the reform of court orders in juvenile court cases. So I think he'll share with us about that today as well. So without further ado, let's welcome Louis.
Thank you, everybody. Oh, gotta get targeted here. Thank you, everybody, for being here. Thank you for those who've tuned in on the webcast. And thank you for the introduction. Phenomenal may be an over-exaggeration, but in any case, this is a basics training oriented program oriented really towards a parent's attorney. I recognize there are some who are not parent's attorney. That's okay. I'll be gentle. During my portion of the program, I will be reviewing the standard judicial court orders that I've seen. I've kind of, as been mentioned, we've been working on trying to get some standardized court orders for the state of Illinois, and we're just beginning that process. And we will be talking a little bit about the rules of evidence that apply in the juvenile court from the beginning of the juvenile court case through the best interest hearing. Along the way, I'll try to share some additional information that may not be in your materials that I think might be helpful to the practitioner in the juvenile court. Now, right off the top, I do want to say I do have a pet peeve, and that is that I'll refer to it as the juvenile court. It is not the Child Protection Court or the Children's Protection Court. There is no such entity. The statute clearly designates it as a juvenile court. So that's a pet peeve I have, but let's make sure we understand what we're talking about. The juvenile court, it was one of the, I call the original specialty court. We have specialty courts in mental health, DUI, veterans. The juvenile court is one of the original specialty courts. And the idea was that, like these other courts, is that it was intended to be a non-adversarial court. Everybody was going to be pulling in the same direction, trying to get these families and keep them together or get them back together. And as a result, we have developed a statute that has some fairly relaxed rules of evidence. And that is predicated on the idea that this was a non-adversarial forum. Obviously, things have changed a little bit. In some jurisdictions, it's still non-adversarial, in others, it's much more adversarial. And whether we need to change the rules to reflect that will be a matter of opinion. We know in Illinois that there is a disproportionate number of parents involved in the juvenile court system that are poor and minorities. You might be interested in knowing that 60 to 70% of poor children are going to be in single-family households. About 6 to 7% of children, more affluent children, are in single-family households. So many of our parents are going to be single parents, single-family parents. The other reality is that they have fewer resources, and they can't really count on the support of family or friends. In fact, in some cases, their friends or their families are the problem. And so they don't have that support system. And so it's important as parents attorneys to let all the stakeholders know in this process that our clients do not have those resources. They don't have the things that so many of us take for granted: transportation, housing, food. So as a parent attorney, sometimes our role is making sure that sometimes we're more social workers than we are attorneys. And of course, to some extent, we are civil rights attorneys because of the situation. Now, we have a lot to cover, and frankly, I'm kind of combining two big concepts: the orders and the evidence and the basics. So I want to get kind of started here, and I'm going to probably kind of go through a little quickly. If we have time, we may backtrack a little bit. I just don't know timing-wise where we're going to end up. So let's get the ball rolling here. So we all know, if we look at Section 1-5 of the Juvenile Court Act, we know that there are certain rights that are set forth in the statute. And that's the right to be present, the right to be heard, the right to present evidence, and the right to cross-examine witnesses, the right to examine the court file and the records, and the right to be represented by counsel if you cannot afford counsel. Now, I as a parent's attorney, this is probably the most important section of the statute, because it's clear that the statute, but that legislature, having given you those rights, intends for those rights to be exercised and used. So, for example, if your client has a right to be present, then we can glean from that they have the right to have adequate notice of whatever's going on. If they have a right to be heard, they have a right to put on evidence, and the right to present evidence, the right to cross-examine witnesses. These rights are universal to Juvenile Court Act. In every proceeding that we have in the Juvenile Court Act, you will have that right to cross-examine a witness. It doesn't specify just at the adjudication or just at the dispo. So it's important to know that these rights are there. Now, in a juvenile court proceeding, the first issue you tend to run across is the venue issue. And under the statute, venue is proper where the child resides or where the child is found. Now, if you happen to have the misfortune of working in a jurisdiction with a lot of hospitals and medical institutions, you're going to end up getting a lot more children involved and a lot more families involved in your county than probably you even have in your county. And we get a lot of that. You know, the child comes in injured to the hospital, treated, they determine that there's possibility that there's abuse. That's oftentimes opened up in the county where the medical provider has provided the assistance. Similarly, if a baby is born positive, for a controlled substance, very oftentimes that case will be open in the county where the medical medical attention has been provided. So, so venue is pretty liberal, all right? Even if theoretically, I suppose, if the child's just passing through the county, they would have venue if they were able to get the petition filed quickly enough, and so forth. So that's important to know. Now, and I will, in our situation, a lot of times, like Peoria County, we have three. Well, we used to have 3 hospitals. There's 2, but we have a lot of medical providers, and we do find a lot of cases that are from outside our county. And so, as a public defender, we end up representing a lot of folks that don't even live in our county. So I guess you can think of it as a subsidy, but it does keep us busy. Now, the other thing about, once you get venue figured out, then, of course, you have to have personal jurisdiction. And personal jurisdiction, we all know how that happens. Typically, somebody's served with the summons. And that's pretty standard even in the Juvenile Court Act. However, with respect to children under the age of 8, the court can appoint a guardian ad litem or custodian to accept service on behalf of that child. And that child, and the court would have jurisdiction. The other thing is that if you don't know they're your client yet, but if the parent happens to show up in court because the caseworker or the DCFS investigator said, there's going to be a shelter care hearing, you need to be there, and they happen to wander into the courtroom, the way I read the case law, there's a really good chance that they're going to have, without service of summons, the court's going to have personal jurisdiction over, particularly if they ask for an attorney to be appointed. So it's very, very easy for the juvenile court to get jurisdiction. Having said that, there are times, for example, where the parent doesn't show up, doesn't get served with summons, or is served at the wrong place. Oftentimes that is the case. Or they are served by publication. And when they are served by publication, there is a special section in the Juvenile Court Act for publication. It's very similar to what we expect from publication under the regular Code of Civil Procedure. It's slightly different, but it still requires that a diligent search be made. And I think it's In re Dar-C, D-A-R-C, capital C, is a Supreme Court case where they didn't do that. They didn't do a diligent search. They served the person by publication. They proceeded with the juvenile court case, and it ended up being reversed because they didn't check the yellow pages in Cook County, which is amazing. I don't know. But anyhow, so they still have to follow these rules. I mean, it's not that relaxed to get personal jurisdiction. The other thing, if, for example, and we see this happen from time to time, the mother decides, I'm pregnant, I've been in trouble with DCFS before, or I'm currently in trouble with DCFS, I'm not going to have this baby, in Champaign County, McLean, whatever. I'm going to go to another state, and nobody will know the bit, and I won't have to give my child up. Well, if the father's still in the county and the mother's intending on returning to the county, there's a case that says that county has jurisdiction over the child and the parents. So you can see that this is not your typical civil procedure. The other thing we need to talk about a little bit up front is we're very accustomed to having either, depending on which jurisdiction you're in the state of Illinois, either having the Department of Children and Family Services filing the petitions, the juvenile court wardship petitions, or the state's attorney in the county. It turns out that any responsible adult can file a petition. Of course, that's about all they can do. They can file the petition. The state's attorney is the one that's responsible to decide whether they want to prosecute it. But it is important to know that about anybody can file a petition. And anybody can file motions along the way who are parties to the proceeding. Now, the contents of that petition that you see initially really must allege in sufficient factual detail the abuse, the neglect, or the dependency, whatever it is that they're being alleged, which we understand that it makes sense. If for some reason there's a pleading defect, for example, there's a petition that's filed that they were seeking to find a parent unfit, but they failed to ask for that in the prayer for relief, or state used the terminology like permanently terminated rights in the termination petition. If they fail to allege those things, it's important to raise those objections then and there at the trial level. Otherwise, it will be treated as waived. So make sure you do that. Now, the other thing that's unique about juvenile court is that the wardship petitions have to be verified, meaning, basically have to be sworn to. So that would be a defect. If you receive a petition that's unverified, then the response is to seek to dismiss the petition. It doesn't comply with the Juvenile Court Act. Now, it won't happen automatically. You will have to file a motion, but they do have to be verified. And of course, if under the rules of civil procedure, if that petition is verified, then your answer will need to be verified as well. Now, the verification in Illinois for the juvenile court proceeding has been very loosely adhered to. Essentially, we don't see the typical language, section 1-109, under oath I will, subject to perjury or whatever. It can be just a sworn with a notary public saying that it's sworn to. So I wouldn't recommend it, but it is something that has passed muster in some cases. Okay, so so there are some time frames in the Juvenile Court Act that we need. I'm just going to touch on the main ones. There are many different time frames. This is probably the key ones, and one of them is basically from the date that the child is removed from care. A case plan has to be prepared within 45 days of that. Some of us think of it as a service plan, case plan, and that's kind of important because time is of the essence in juvenile court. We know, those of us who practice in juvenile court know that when you get to the Adoption Act, you've got these 9-month periods, and if things don't get done, they don't get their services done, they could risk being terminated on. So it's important as a parent's attorney to make sure that you know what services your client's going to be asked to do as soon as you can know. And sometimes, and every case is different, and I can't make a generalization because, for example, if there's a pending criminal case, you may not want your client to talk to anybody, do any integrated assessment, or do anything in that nature, so you're not going to get a service plan or a case plan. But in most cases, you're going to be able to say, go ahead, do it, let's see what services they're going to want you to do. And so that 45-day time frame is more important to the parent's attorney than it is probably to just about anybody else in that courtroom. So don't be afraid to insist on getting some kind of service plan or case plan if the child's removed. Now, the second important date is sort of the 90-day rule, which is basically the adjudicatory hearing must commence within 90 days of the last person who served in the case. At least that's how we interpret it. It's maybe subject to different interpretation, but that's how we interpret it. And so if it doesn't start within 90 days, then and it's a mandatory provision, so it must start within 90 days. But the key, of course, is the language. The language is it must commence, and they've changed the statute in the last few years. But it used to be if it didn't start at all, it could start, but if it didn't finish, you were dead in the water. But now it's if it doesn't commence within 90 days, meaning that if they can start the adjudicatory hearing, and then with good cause, obviously, it can be continued to a different date. Then they get past that 90-day rule. But if it doesn't start at all and nobody's waived that 90 days, then you're going to file a motion to dismiss the petition. And the petition will and should be dismissed. Now, that doesn't mean the case is going to be over with. It doesn't mean they won't refile. But, you know, if the child's in shelter care, that goes away. All the orders based on that petition are no longer valid. So there is some incentive to some degree to keep an eye on those dates. Now, I will say that it's very easy to inadvertently waive that 90-day period. Your client doesn't show up for the first appearance, is defaulted. You come in and say, I've moved to vacate the default. You have just implicitly waived the 90-day period by making your motion. So be careful. You know, in some cases you have no choice. You will end up waiving it. But you know, motions, different things of that nature can have the effect of waiving that period of time. Now, the adjudication, well, it's 90 days from service, 6 months from initial removal. The dispositional that's kind of a weird section, because if the child is, the way I read it, if the child's not taken into temporary custody, the dispositional could actually occur 12 months later. Looking at 2-22.5, 2-28.2. If the minor is in substitute care, there must be, no, I'm sorry, strike all that. That's the permanency review. The permanency review would happen 12 months later. If the child's not in custody, if the child's in custody, it must happen every 6 months. Sorry about that. So those are important time frames to kind of keep an eye on. I find that depending on the court schedule, everybody kind of tries to work together. In our jurisdiction, we all work very hard to make things flow, to make it work. It usually works to the advantage of everybody to do that. I have up here, and you have in your materials, a preliminary order. In our county, currently it's called an arraignment order. We are working on reforming that because, as you all know, arraignment orders are not civil cases. Arraignments are strictly criminal type of order. So we've renamed it preliminary order for lack of a more creative way, but there is I cite to 219, which refers to preliminary matters and preliminary orders. So I think under the Act, that's what's intended to be. There's always a first appearance. There's always an initial order. And this is our attempt to try to come up with what that order would look like. And we basically took what is currently our arraignment order, modified it to fit with the Juvenile Court Act. So at least you have something that you can look at, that you can take back and say, this is kind of what it should look like when they show up for the first time. And there are a whole host of things that have to be dealt with. Obviously, jurisdictional issues are always going to be dealt with all along the way. And you'll see in subsequent orders that we still have jurisdictional language in there, because as those of you who practice in this area know, people kind of fall out of the sky at any point in time. You don't know who's going to be your parties. You really don't know, except for perhaps the mother. We keep the jurisdictional language in throughout. And the other thing, and you know, and of course I've got the publication stuff and the diligence search, and I put that in these orders. We put that in the orders to remind everybody who's in this courtroom of what check boxes we need to do. I think I'm a big believer in having to check boxes to check. If you don't check those boxes and they're not checked, you're probably messing up. You're going to miss something. You're going to forget something. And this is a good order that lets you go through these boxes and make sure that everything's been covered. One of the things I'm going to mention at this stage, and I may revisit it later, is the problem of the putative father. And if you look at sentence 7, paragraph 7, we deal with that. It turns out that under the Juvenile Court Act, and as we know, putative fathers are exactly that. They're putative. They're not legal fathers. and they are therefore not entitled to participate in the juvenile court proceeding per se as parties. So the Juvenile Court Act has devised a mechanism for the state's attorney or the DCFS, whoever's filing the petition, to address that issue. And the way it is supposed to be addressed is that a notice would, once the putative father is identified, a notice, and there's a statutory notice form in the Juvenile Court Act, will be sent to the putative father, basically giving the putative father two options. One, you can come in and you can declare your paternity, or two, you can disclaim your paternity. If the father disclaims the paternity, the putative father, then the father we're not required to give him any more notice as far as the case goes, at least under the statute. If they declare that they are the father, then they can participate in the case. So I don't see that happening a lot. I don't think people realize it's in the statute, but that's really the proper way to deal with it. And there's like I said, there's a statutory notice and language in there that can be lifted out of the Juvenile Court Act and used. Well, I could talk a lot about paternity and putative fathers, but I'm going to bite my tongue and move on. The other thing that you want to know as soon as possible in a juvenile court case is who is your client, and in this particular instance, is your client eligible to be a member of a Native American Indian tribe or a registered member of a Native American Indian tribe. And that's pretty important. And so, of course, I have a form answer, and my form answer, because I like check boxes, I have check boxes that I ask them that question, and they will answer that. It's surprising. You cannot assume, I shouldn't have to say this day and age, but you should not assume that if they're not wearing tribal outfit, that they may not have eligibility for Native American citizens, So, and it has been surprising sometimes who have been eligible or registered Native Americans. And even in the Midwest here, where we don't have a big Native American population like Oklahoma or Montana, we do run across it. We have run across it. And so it's an important question. I think it's an important question for the parent's attorney because, as we'll discover later, it alters in very major ways how that juvenile court case will proceed. From the state's attorney's point of view, there's some jurisdictional issues and making sure all the parties are part of that case. So everybody has a stake in making sure they identify this as soon as possible. We put it in our preliminary order, and it shows up in other orders as well because, again, we don't know who's going to show up and when. Also good to ask whether they're foreign nationals and there's citizens of other countries, and so that the consulates can be notified. The other thing with the preliminary order is that that's usually, and you can think of it as a first appearance order, or you can think of it as, if you have a criminal mindset, as the arraignment. That is also really, from a parent's attorney's point of view, where a public defender is likely to be appointed. You have all the parties, you're going to set it for an answer, or you're going to set it for whatever. They're all there. It's a good time to for the judge to decide, well, do you want an attorney? And usually the screening question that we see is, can you afford an attorney? Now, hopefully your counties and jurisdictions have a little better screening process, but that tends to be our screening process. And what do you think the majority of the answers are to that question? Of course, nobody can afford an attorney. So, of course, the public defender's office gets these folks. But it's really intended only for people who are unable financially to employ a counsel. Now, I'm going to kind of take a little side step here and get back to the putative father things. my position, and it's not universally been adopted or really taken up to the appellate court or anything like that, is that since a putative father is not a party to the case, he's essentially a stranger on the street that a name has popped up. My position is that the putative father is not entitled to an attorney until such time as they declare their paternity or establish their paternity. Now that's self-serving to some degree, but it is what it is. The statute's pretty clear that a party is entitled to counsel, not somebody who's not. Now, there's probably going to be some dispute on that. Of course, this is where the parties typically are admonished of what their rights are, which we've just covered, and we're oftentimes guardian ad litem may be appointed as well, if not already appointed, and that's important because as a guardian ad litem, the statute requires at least a one in-person contact prior to the adjudicatory hearing. So we need to get that JL appointed and give them a chance to get out there and talk to the foster parents, meet with the child, and so forth and so on. Now the court can excuse that, but I can't imagine why it would. So I'm just going to move on then. I think not keeping up with my. So now we're at the shelter care. Everybody's shown up, and at least we think everybody's shown up. And we're at the shelter care. Some people call it a temporary protective custody hearing. I'm lazy. I refer to it as a shelter care. This is essentially where the determination has to be made based, again, on the petition that's been filed, whether or not the child needs to be taken into protective custody. And so that's a pretty critical step. Now, that has to happen, again, within a certain period of time. I think it's 48 hours from the time the child's taken into protective custody or removed from the home. What a lot of people may not realize is that if that doesn't happen within the time frames, what are you going to do? You need to file a motion to dismiss, and it should be granted. Now, I didn't realize this, but did you know that protective custody is taken at the point a hospital is instructed not to release the minor to the parents? So it may not be when you think it happened. It may have happened a day or two earlier. So it never hurts to look into that. And if it doesn't happen within the time period, then you will need to file a motion to, in this case, a motion to have the child released back to the custody of the parent. That's the remedy. I will touch on the subject of safety plans. You will hear about safety plans that DCFS, typically it's investigators put together and offer to the parents as a means sometimes to keep the children in their custody. And it's not well drafted usually, but it is there. And the important thing to know about safety plans is, yes, DCFS can do them, but two, they're voluntary. These are strictly voluntary documents, so that the notion that a parent failed to abide by the safety plan is a little dangerous because the courts have made it clear in Depew versus Samuels that the reason we let these happen, the reason we let these safety plans happen, is because they are voluntary. The parent doesn't have to do it, but if they choose to do it, you know, then it's like any other contract, if you will. But I would argue that the voluntariness of that safety plan extends throughout that When the parent wants to revoke it, they should be able to revoke it. Really, the only penalty for revoking it should be the decision by DCFS to either take the child into protective custody or not. That really should be the exclusive penalty. But the parent should notify them that I'm no longer in agreement with the safety plan. I think that it would be very dangerous for the state's attorneys and public guardians to suggest otherwise. I think they're going to run into problems. The shelter care, so that's that. So the shelter care obviously has kind of a burden of proof, probable cause that the petition, the allegations of the petition will be proven. Yes.
You're talking about a safety plan prior to the shelter care hearing?
Yeah, sometimes you'll have an intact family,
Okay.
and they're intact because there's a safety plan that's been signed off on, and the safety plan basically says bad daddy can't come and live in the home during the pendency of this case, whatever happens. So yeah, you will run into the safety plan at that point.
So if daddy, son, and mom, we voluntarily will not participate in the safety plan, and protective custody folks say, you know, flesh and blue like it. Can you say that that is reason enough the parents have the right to choose not to participate, and their right to participate doesn't mean that the children. It feels like in this county, as soon as you don't agree with the DCFS,
there has to be a nexus between the wish to the child and what the parents are doing. You're really saying I'm not going to cooperate with you. There's no bearing on the safety of the child, and the state's attorney is running some risk that they're going to screen it in based on, well, they refuse to participate in the safety plan. Well, is that safety plan reasonably rationally connected to a safety issue in the household, or is it just a tool?
And the question, and they can't hear you, so I'm going to try. The question was essentially, you know, there's a risk to the parent if they don't abide by the safety plan, if they reject it at some point, of having DCFS come in basically and take the child. And that is exactly the risk that I was proposing, that if that's the penalty. You do the safety plan. If you don't do the safety plan, then DCFS has to make the calculation as to whether or not they will be successful in the shelter care hearing. Because remember, if they remove the child from your care, right, that triggers the 48 hours for the shelter care and all the things we're just going to talk about here in terms of shelter care. Now, it's conceivable that a parent may make the calculation themselves, that I've looked at the allegations in this petition. There's no way that they're going to succeed on the shelter care. Plus, I've done a bunch of services. I've done a lot of things. And this person's, for example, the father's incarcerated now. Wasn't incarcerated at the time that we signed the safety plan, so I don't really need it anymore. There are a variety of things that can change that can cause a parent to make the calculation that, one, they're either not going to remove their children, or if they do remove them, they probably would not be successful at the shelter care hearing. Wow. So,
Let's not forget Hernandez.
right. Well, this is a basics training, so I'm trying not to get too far. But yeah, they do have to have. That's a whole new box. But there are some constitutional issues and some Fourth Amendment issues that apply in terms of taking custody. So what happens at the shelter care hearing? Well, first of all, rules of evidence apply that would normally apply in the Code of Civil Procedure, but also Section 218 applies, except for, I think there's a section about minors' testimony. That section does not apply because it's not, that section does not, this is not an abuse and neglect proceeding. The shelter care hearing, I'm just quoting what the cases say, the shelter care hearing is not considered an abuse or neglect proceeding. So to the extent that you have language in Section 218 that does not state that this is admissible in an abuse and neglect proceeding, that section of 218 would not apply. And I think there's at least one section that does not apply to the shelter hearing, and I think it's the minor's testimony. So what's admissible evidence at the shelter care hearing? Well, evidence that would relate to whether there's probable cause to believe that the child's been abused or neglected. Now, I dropping the dependency because that's there too, but I'm just for brevity, I'm just dealing with abuse and neglect. So obviously, any evidence that would be relevant to prove probable cause is admissible. Evidence that, and once that's been established, evidence that's relevant to the determination of whether there's been immediate and urgent necessity for the shelter care is relevant to show whether reasonable efforts have been made to prevent the removal. And so basically, you can just look at the shelter care, the temporary shelter care, that section of the code, and it basically tells you, has there been, those elements have to be, evidence that supports those elements will need to be proven. Now, if you are, let's say shelter care has been taken, the order has been entered, there's still hope if things change. You can come back in, file a motion to vacate or to return custody. In that case, you're going to have to show it's no longer a matter of immediate urgent necessity that the minor remain in shelter care, that there's been a material change in circumstances, or there's some person other than the person alleged to have abused or neglected the child who is capable of assuming temporary custody, or you can show that services have been provided and whatever the problem was before has been successfully eliminated as a result of services. So now you can see why we want that case plan, we want that service plan as soon as we can get it, because it's quite conceivable, not very often, but it's conceivable that your client only needs to do 1 or 2 services and can probably knock them out in a few weeks, even before the adjudication. Why wait to the adjudication? Why wait for dispo? If you got the services done, under the statute, if you can show that the problem has been dealt with, at least by the person seeking to have the shelter care vacated, they ought to be able to go in and have it changed. Let's see. The burn does kind of shift, though, at that point. All right. So I think we're at the, there's your temporary shelter care hearing order. Again, like I said before, we're always dealing with jurisdiction because you never know who's going to show up. So you always have to make sure that you provide for that. And I've laid it out. One, has probable cause been found? Does it exist or does it not exist? If it doesn't exist, then if they don't find probable cause, then you're done. That's the end of your shelter care hearing, basically. Now, if they do show that there's probable cause that they're going to prevail, basically, that there's been abuse or neglect, then it's incumbent upon the petitioner to show that there's immediate and urgent necessity for the removal, and so forth and so on, or that reasonable efforts have been made to try to prevent the removal. And that's kind of a real tricky thing. It's pretty easy to come in and say, well, we're going to be able to prove that there's been abuse or neglect in all likelihood. We're probably going to be able to prove that there's an immediate urgent necessity to remove the child. But part and parcel of that will be, has there been some effort made, reasonable efforts made to prevent that from happening? And that is the part of the shelter care hearing that is often overlooked and often ignored. It is an affirmative obligation requirement that it be proven. And if that doesn't happen, then it may fail. Now, I will be honest and say that I think very few judges will treat it that way, but that is part of the statute. The whole idea of the Juvenile Court Act is to not remove children from the home. No matter how horrendous we think these parents are, the number one priority isn't the best interest at this stage. That doesn't happen until after the adjudication and after. The number one thing in juvenile court is to try to keep these kids in the home. And if it can be, if that can happen, you know, through a safety plan, an agreed order of protection, let's do it. As a parent's attorney, it's disconcerting that there's this notion that there's a problem here, no harm's done, we'll take the children and put them in foster care. Believe me, there's a lot of harm done to children when they get into foster care. Sometimes it's worse than what is alleged of the parents. But we don't seem to acknowledge that like we should. So I think this part of the shelter care hearing is an important part. Have we made efforts to try to keep the children at home? And that's, I think, an acknowledgement by the legislature that there is trauma, there is harm to children when you remove them from the home. Now, a lot of the times, that's not going to be possible. You know, it's not going to be possible. They're going to have to be removed from the home. But I think an effort should be made, and that should be before the court. Before I get too far on the temporary shelter care hearing, this is another pet peeve that I have, and every jurisdiction is different. But I've been in jurisdictions where there is this notion that the shelter care hearing is basically just an opportunity for the state's attorney to come in and make a proffer as to what evidence they would put on to show that there's probable cause that they would support the petition. There's nothing that I found in the statute that, unless the parties waive it, that prevents there from being a full evidentiary hearing, or that the court can consider just a straight proffer, or anything from a caseworker not under oath, not subject to cross-examination. This is a regular hearing, just like every other hearing in the Juvenile Court Act, and the rules of evidence apply. So now, as a practical matter, a lot of times the parents' attorneys, GALs, and the state's attorneys will say, oh yeah, go ahead, do your thing. You know, we know we're not going to make a big issue of it. But just so we understand, that's not what the statute does provide for evidentiary hearing. It's a good time, and when we talk about reasonable efforts to try to keep the kids in the home, once that shelter care hearing order is entered, now you have an order that you can couple with the order of protection section of the Juvenile Court Act. You can't do orders of protection unless there's an order in your juvenile court case. But once you have that shelter care order, you can do an order of protection. The judge can ask for it. So if you're looking for a way to keep the kids in the home, if there's no safety plan, you can ask the court, you know, will you keep the children at home if we agree to an order of protection that bad daddy's not going to be around. I hate to be chauvinistic that way, and that order can be entered, and that child can remain in the home for the duration of the case. Now, obviously, if mom screws up and daddy comes in the home, all bets are off for sure. And that, of course, that never happens. But no. So anyhow, just want to make sure. Again, case plan. This is definitely the point where you're going to insist on the case plan, which is now going to be definitely due within 45 days. I'm going to touch on something that Alan, who's going to be talking to you later, and myself, and that I don't know how we missed it, but it's in the right place, but we're always looking in the wrong place, and that is the subject of visitation. Obviously, when the child's in the home, you don't have to deal with visitation. The child's in the home. But once the child's removed from the home, then we have to talk about visitation and how that's going to work. And I would just invite you all to look at the Juvenile Court Act at section 10.2, 2-10.2, and read it. And it would be very enlightening. It was very enlightening to us. And the language is very clear that the legislature wants parents to have visits, and they want to have it liberally, and they don't want it just in the agency office for 1 hour a week or 2 hours a week. And it's not to be in setting up visitation. the convenience of the agency is not a factor. So if they come in and say, well, we don't have enough staffing, we can't do this, we can't do that, sorry, not an issue. So here we go again. We have to get creative. Now we know that the legislature wants liberal visitation. They want it to be in a home-like setting, and they don't care whether it's convenient for the agency. What do? Well, as a parent's attorney, we just don't ever find my clients unfit, and then it's not a problem. Don't ever take them from the home. But there are solutions, and those solutions tend to be delegating, deputizing, whatever you want to call it, other people, other adults that are responsible, that can attend the visits, can participate in the visits, and allow for that flexibility. It doesn't have to be a caseworker who's probably busy working on their next case report anyhow. Yeah, so there's nothing in the statute that requires. Now DCFS may have a problem with that, right? Because they're the guardian. They're thinking, if something bad happens, it's on me. And so they may have some reservations, which my position is just do a background check. Make sure that person passes muster. And if they do, give them certain guidelines and parameters. And if they breach those, you're probably going to be okay. But I'm not their attorney, so I don't have to worry about it. But that's the way it is. That's just the way it is. And, you know, kids get hurt all the time, whether they're in foster care, whether they're being supervised by other parents. It happens, you know. But I think the penalty has been far too severe for parents in terms of literally having 1 or 2 hours of visits a week. That's, I don't think, that's almost unconscionable in many situations. And of course, it's, as we know later on, when we start doing bonding assessments, we're like, gee, I don't know, there's not much of a bond anymore. Well, this is the first step in making sure that bond exists, and that's really what the legislature wants. So, sorry about that, but I wanted to touch on that. And look at the statute. If you disagree, great, but I think the language is pretty clear. All right, let's
It also
move.
has something to do with the safety of the child, because if the child is not being seen by anybody outside agencies, then there's no assessment, there's no one holding their feet to the fire to make sure that the child is safe.
Well, hold who? So the statement is that the child's safety, there's nobody looking out for the safety of the child. Well, okay.
Medically safe.
Right.
Sexually safe, whatever.
All right. Well, true. Well, yes and no. I mean, DCFS is still guardian, right? So if you're the parent, if you're a parent of a child, the way DCFS would essentially sort of a pseudo-parent, and you decide you want to go to the movies Friday night with your spouse, what do? We try to find a responsible babysitter to watch your kid. Do we look in the crime blotter to find that babysitter? No. We probably ask friends and family, hey, you know anybody who's a good babysitter? And that's how that works. And so that's how it works in a more elaborate way with DCFS. They will do a background. Can you give us their date of birth and social security number? We want to run some leads and can'ts. If they pass, then they're probably okay. And by the way, here are the parameters. They can supervise, but only on these days, so we know, right? You're going to tell us is on Wednesday nights from 5 to 7, grandma is going to supervise the visits. They know when that visit's happening. If they want to do a spot check, they can go do a spot check. They don't have to, but they can. The other thing I will say, and I think it's a real misconception, is that the visitation that's scheduled in juvenile court is not intended to be a laboratory for determining whether or not the parent is able to parent. So often we see in reports it's sort of like, well, she gave him the wrong snack. You know, she gave him some candy. That's, you know, you're horrible. Or they weren't interacting like they should, you know. they were watching TV instead of interacting with each other. Well, there's nothing in the Juvenile Court Act, in the statute of visitation, that says this is for the benefit of the Department of Children and Family Services. This is for the benefit of the agency to be able to observe the parent and how they interact with their child, whether they parent appropriately or not. That's not the purpose of the visitation. Visitation is to maintain that bond. Number one. Does that mean that you can't observe it? Sure. You can have the outside supervised visit, unsupervised visit, or supervised, whatever. But you can have them in the agency office. You can take a look. If that's an issue, you can look at it. But just so we understand, that's not the primary purpose of visitation. And so often that's misconstrued in the statute. That's not in the statute at all. And frankly, as a parent attorney, it's a little offensive, because so many of us who have children don't interact with our child every minute of every day the way we might be expected to. Believe it or not, I let my kid play on the Kindle Fire every now and then. I let him watch TV. And I can do this because it's a natural thing, because there are times like dinner that we spend together and we can interact appropriately. I think that these parents have, in those 1 hour to 2 hour visits per week, they don't want to leave a bad impression. They don't want to discipline their child. It's, I think, fundamentally unfair to say you're going to have visits for 1 hour a week and you're going to spend a half hour of that with your child in timeout to show us, to prove to us that you know how to discipline your child. I'm just food for thought. Okay, so you got me going. I'm sorry, I tried to get past that, but let's move on. Some of the Rule 900 still applies, by the way, to, are you guys doing mediation in McLean? Is that working out? Maybe?
It's still young.
Yeah. So it's in the statute, it's in the Supreme Court rules, and the Supreme Court rules are clear about which Rule 900s apply and which do not apply. Mediation is the one that will apply if the courts choose to allow it to apply. So we're going to move on to adjudication, I hope. There we go. I've got a lot of ground to cover. I better get going. So the burden of proof in a judicatory hearing is a preponderance of the evidence. If you are eligible under Indian Child Welfare Act, it's clear and convincing evidence, which is why it's nice to know if your client's a Native American, right? Because the burden of proof goes pretty high, or at least theoretically it does. The rules of evidence are the normal Code of Civil Procedure rules of evidence and Section 218 of the Juvenile Court Act. So I'm just going to touch on a few things. There's so much to talk about here. Let's see where we're at. So what's admissible? Obviously, evidence that's relevant to the allegations is admissible in an adjudicatory hearing. There are certain statutorily prescribed evidence in Section 2.3. That's really where all the neglect and abuse stuff you find, just look at that section. That's all going to be admissible as it relates to the particular petition. Evidence pertaining to grounds for unfitness under Section 218, there's I'll get back to that. And then there's the prima facie evidence that's set out between A and K of Section 218 A through K. That's sort of, I think that's the fetal alcohol baby, the meconiums, those kinds of things. That's prima facie. And there's a whole host of them. I'm not going to belabor it. Evidence of anticipatory neglect is admissible, 218.3. Hospital and agency business records under 218.4A are admissible. This is an area that I've worked a lot in. I'll just say a couple things. One, about that section, about the records. Obviously, they need to be certified and delegated records to get in. There's a parallel rule of evidence that allows business records under the normal rules of evidence. It's slightly different. I think it's a little more onerous to some degree. Under the Juvenile Court Act, if you have a record and it's properly certified and delegated, even though there's hearsay in it, it will be admissible at the adjudicatory hearing. Now, I still haven't persuaded every appellate court of this, and I'm working on it, but I've not been totally shot down on it either. And that is that if you read the statute, it's pretty clear what is and isn't admissible as a business record. First of all, the language of the statute clearly says that you're referring to a hospital, public agency, or private agency records. So we're really just talking about those kinds of entities' records that are coming into. If it's some other business record, you're going to have to go under a different section under the Code of Civil Procedure to try to get that in. So if it's not a hospital record, if it's not a public agency record or a private agency record, then it's not a qualifying document under Section 218. And so using the normal rules of statutory interpretation, we need to figure out, well, we know what a hospital is, although I've had some argument over that. I had some success with that. But we also know that looking at the Juvenile Court Act, there are definitions of certain things, and there is a definition of agency under Section 1-3 of the Juvenile Court Act. And so if you want to be a public agency or a qualifying private agency to get your records in, you better be a facility licensed for placement. So it's just not any agency. So your lab that's taking your drug drops, they're not certified to have children placed with them. So they would not qualify under 218. So I'm going to move on. I've got a lot to cover, but there again, read the statute, understand what is and isn't admissible. The other thing I will say about Section 218 is that, and sometimes I'm not as careful as I should be, but when the state or petitioner or whoever it is, really even parents' attorneys can admit this stuff, seeks to introduce a certified and delegated record, take the time to look at the certification and make sure that the person who's certifying it is the proper person, the keeper of the records or somebody who's responsible. And occasionally you don't have a proper certification delegation, in which case you will object that it's not properly certified and delegated. And it should not be allowed. Indicated reports are admissible, and soon to be perhaps unindicated reports, which blows my mind that that is even going to pass. But anyhow, previous statements of the minors per 218(4)(c). So your minors, normally we deal with minors obviously in juvenile court a lot. The normal problems with a minor testifying are one, competency to testify, and two, oftentimes it's out of court statement that they made. Again, bad daddy or bad mommy, touched me in the wrong place, or stuff like that. So normally that would not be admissible if it was out of court because it'd be hearsay. Normally the 5-year-old may not be competent to testify, for I think obvious reasons. But the Juvenile Court Act is not bothered by those minor little things, and it has decided that all children are competent to testify, and if they make a statement out of court, then that's admissible too, but cannot be given any weight if it's not corroborated. So just so you know. So the battle really is over what's corroboration. Just so you know that physical injury or in and of itself would not be corroboration. Other hearsays typically not considered corroboration of that. So there are some limits to it, but that's that. Now that doesn't mean as a parent's attorney you can't argue, well, she's 2 years old, she can barely talk, I don't think you should give much weight to that. Good luck. The other thing Well, so we know about the failure to thrive. So if the child's removed from the parent and suddenly starts thriving, then that's evidence that's admissible, even though it's post-petition. So the question arises oftentimes, well, what about post-petition evidence? There's a good example of where post-petition evidence is admissible. But there are other examples, where it is relevant and it's probative, where the court can admit post-petition evidence. But that's a very good example of where it would be admissible. Trying to stay on top of here. All right. Obviously, evidence that the minor is a chronic truant is not a hard thing to prove usually. And then judicial notice of prior sworn testimony in your case, say something happened in shelter care hearing, would be admissible, but only if they were represented by counsel at the time. So it's not wholesale admissible, but we would not be surprised by that. One of the things that you do run across in juvenile court and at the adjudicatory hearing is evidence of what we call anticipatory neglect. And that is where there's evidence that's presented that another child was neglected or abused, and they're using that evidence in a case as to another child to show, I guess, propensity of some sort. That would be admissible, but a few things to mention about that. First, it is not clear from the statute that if the child that they're introducing evidence on was abused or neglected was not in the home or under the responsibility of the person who abused and neglected that child, that is not, I think, within the parameters of what they're thinking of in terms of anticipatory neglect. They're thinking of children that are injured in that household, in that family unit, not somebody who did something 10 years ago to, some kid ran them over on, or whatever, to introduce them. So, and there are a lot of reasons for that, and I'm not going to get into all of them, but understand that it's not just this broad category idea that if you hurt another kid somewhere in your life and you're not related to this child, or you never were in this family unit, that necessarily gets an evidence under that particular section. It may get in some other way, but that's not what it's intended to do. The other thing to know about anticipatory neglect is that it's not a per se rule. So just because mom had a baby born positive for a controlled substance doesn't mean that she's neglected the other child. Now, it's definitely proof, prima facie proof she's neglected that child, but it's not proof positive that she's neglected any other child in that household. For example, you have, she just started using, she has a baby born, but all of her previous children, she went to the hospital, she was clean for all of them. And she stopped using before you got to the adjudicatory hearing, but she just happened to have a positive for that particular child. So it's not going to be per se. It's not automatic. It doesn't, oh, we won. You've abused another child or neglected another child. We get to call all these other children in and include them in the neglect. So you literally could have a petition, depending on how you do it, whether you consolidate them or not. You could literally have 3 children and have the court find neglect as to 1 child and not neglect as to 2 other children, if there's really nothing else other than that anticipatory neglect. So a prior finding of neglect, sometimes you run into it where you were found to have neglected a child back in 2007, and now you've had another child. Maybe that case didn't end well. It ends up in the petition, and really there's not much else. That's pretty much the core. I usually see a few other things like, well, you don't dress well, your coordination, whatever. But if that's all that there's there, then you might have a chance of being successful because it's not, again, not per se evidence of current neglect. So if it happened in 2007, you got a kid in 2015, a lot has changed in that time. And the court can consider all of that nothing's happened, no other child's been hurt. A lot of times we find, I'm sure we all find situations, what, you had a kid, you were found unfit, you were terminated, and you've been living with this kid for, what, 3 years, and we just found out, oh, we got to file a petition. And a petition gets filed, and it's like, well, problem is the kid's getting straight A's in school, the kid's doing well, you know, whatever. And so the parent has really changed. And so the anticipatory neglect is really not, again, per se evidence of neglect, but it can be admitted. Got the adjudicatory hearing order here. Again, as you can see, jurisdiction keeps following these orders because, again, anybody can show up at any time. It's important to make sure that that doesn't get ignored. Obviously, if the baby was relinquished in accordance with Abandoned Newborn and Infant Protection Act, we need to note that. Again, the minor's guardian ad litem, they need to have had made contact at this point or been excused. So that needs to be noted. And then if you look at 11 on our particular order, then we sort of kind of list in a general way the various types of neglect and abuse, you know, and you want to check it off. But the most important thing about the adjudicatory order, other than the fact that they find neglect, is that there has to be a finding, a factual basis for that finding neglect. The court can't just simply say, this child's neglected, okay, dispositional step for whatever. The court has to articulate the basis for the finding of neglect or abuse or dependency. And if they fail to do that, then that's probably going to be an order that gets reversed on appeal. And so we made sure that in our order that we had something in there that kind of reminded everybody of that. So the court can either, in some jurisdictions, they'll write out, you know, what that factual basis is. And I've seen like 5-page court orders, typed court orders, making that finding a factual basis in some jurisdictions. Other jurisdictions are very more abbreviated. Most jurisdictions now probably will use the transcript as the record, as the written factual basis, and the court allows that. But they still have to articulate it in open court, so it's on the record what that factual basis is. What I like to remind everybody who represents parents, and really anybody, is that we all know that not every parent that is involved in the juvenile court is equally culpable for abuse or neglect. Occasionally you'll have a father who's not been involved, didn't even know they had a child sometimes, living in another state, and suddenly get served with papers and discover that they have a child, or have been trying to communicate with their child, didn't know, you know, and then discovered that the mom had some guy come in and he beat the crap out of the kid, you know. So the court at the adjudicatory hearing can say, this, I'm finding there's been abuse of this child, but I'm also finding that this parent, who had nothing to do with it, is not responsible for that abuse. And that's important. I think that's important. And the same with neglect. Sometimes that happens with neglect. And it can be the other way around. I'm not trying to be chauvinistic, but you know, it tends to be the dad who's in the dark or wants to be in the dark, whatever the case may be. Again, as we talked about before, now everyone, I don't have a separate, at this point, I've not done a separate continuance under supervision order. That could be a sort of an intermediate. Obviously, just so you know, you can't have an adjudication of neglect, abuse, or dependency and have a continuance under supervision. Otherwise, you don't have a continuance under supervision. So you can't have that finding made. And so sometimes it's probably better to have a separate order, and then you can put whatever conditions you're going to have as part of that continuance under supervision in that separate order. but every circumstance is so unique, it's really hard to know really how to do one that's universal for everybody. So I kind of skipped over that, but just letting you know. We've got language in our adjudicatory order where it basically says, you know, we're not making that finding. It's continuing under number 13, I think, or it's being reserved. So they're not making that finding. All right, down to 13. Okay, so again, I always, from the get-go, we're always reminding people what's your standard proof, what's your burden of proof. Obviously, for most parents, it's going to be preponderance of the evidence. But if you are, again, a Native American, you're going to have that clear and convincing evidence. I put a checkbox in there to remind everybody, make sure you know what your standard of proof is. Now, I do have reasonable doubt in ours because in our jurisdiction, sometimes we use the adjudicatory order for the unfitness hearings and the termination. And you can see there, and we'll get to that later, that there's even higher standard of proof for terminating the parental rights of a Native American who is registered or eligible for registry. I include in the adjudicatory hearing order, again, making sure that that service plan gets filed, get the ball rolling. I can't tell you, and again, I know every jurisdiction is different, but I can't tell you how often we've had to wait for the service plan. And yes, oftentimes the parent has not been doing what they need to do, but oftentimes it's just delay. And that's killing our parents from getting their services and getting started on it. I'm going to do a Mark Rubio here. There goes my presidential chance. You see it in my orders, I keep pushing it, get that service plan, let's get going on this stuff. Put orders of protection in. Now, it might be a little early for that, or it may already have been entered in the temporary and the shelter care order. Sometimes those will expire at the adjudicatory order, so we put it in just to remind them, are we going to continue that order of protection, or are we going to let it lapse? Oftentimes that's the way it's set up. It will lapse at the adjudicatory hearing unless it's renewed. So we put language in there to try to provide for that. Obviously, you have to have the admonishment. We put it in the order to make sure that nobody forgets it. Not a big deal for parents' attorney in the sense that if they forget it, then we have something to argue on appeal, I guess. But it's there, and you'd rather have something done right. All right. So I'm doing the unfitness stuff after lunch, right? Okay. I'm just trying to figure out what my timing is. So that's the admonition of K down there. All right. So I will say that before I move to Dispo, and I know I've got it on the screen, that so often you see that all these cases are, and I'm going to mispronounce this because my Latin's a little bad. Sui generis is what they refer to these cases, meaning that they're all unique. You can't compare them. That is an unfortunate development because I thought every case was that way. And that to the extent they could be compared, we wouldn't actually want to compare them. But that is an obstacle for attorneys. You say, well, I just had the same facts last week, and you didn't find neglect, and we have pretty much the same facts this week, and you're finding neglect. And you go to the appellate court, and the appellate court says, well, sui generis, tisk. It hurts the precedential value of a lot of things, but it's out there, and it's an unfortunate development because I really don't know where it comes from. Moving on, dispositional hearings, the burden of proof, again, preponderance of the evidence, the rules of evidence, rules of civil procedure, and the rules of evidence, rules of civil procedure, and 218, and I hope I got this, and section 222. So a lot more stuff in a nutshell gets in at the dispo than gets in at the adjudicatory hearing. But let's talk a little bit about the dispositional hearing before we really get into the evidence. First of all, the dispositional hearing is where the court has to determine what's in the best interest of the minor and the public, and decide whether to make the minor a ward of the court. So that's really what's going on. If the court determines that a parent, that the child should be made ward of the court, then obviously you get to the next step, which is, what to do about it. But the primary role of the dispositional hearing purposes is to determine whether the child should be made a ward of the court. If the child is not made a ward of the court, you're done. You cannot find a parent unfit. You cannot order services. Because under the statute, you don't have jurisdiction to do that. Now, we all know that never happens, although it does every now and then. I think actually I had a 4th district case where that happened. Not out of Champaign, but where they found the mother unfit, but they didn't make the child a ward of the court. So they did the right thing. They said, I'm sorry, no can do. We're reversing. So the child has to be made a ward of the court for those kinds of things to get ordered. Once the child's determined to be a ward of the court, obviously, then we're going to look at other things. And the other big thing is what to do with the child or children. Do they stay home, or do they get placed? And again, the statute has provisions for that. If you make the child a ward of the court, if you find the parent unfit, unable, or unwilling, yes, you're going to be able to place them outside the home. This is probably a developing area of the law in this area. The question arises, what if you don't find the parent unfit, unable, or unwilling? Well, the courts that have looked at that so far have concluded generally that you don't have a right to place the child outside the home. And some courts, though, have kind of legislated from the bench, if you will, and said, well, but we can find them fit or able or willing, but we can say that placement is necessary, and then we can remove them from the home. But it's not in the statute. It's not in the statute. And so I would just encourage folks to read the statute, because there's really 2 components to that. But if they're not found unfit, unwilling, or unable, then you have a problem. The other part of it is, I think, and I'm going to cheat here, and bear with me, I'm sorry. I think it's 227 maybe. I wasn't sure I was going to get into this, but I will. And it also says, obviously this is all for reasons other than financial circumstances, but the other component is that the court has to make a finding that if they also left the child at home, that the child could not be, the health, safety, and best interest of the minor would be jeopardized if the minor remains in the custody of his or her parents, guardian, or custodian. This is at 2-27 of the Juvenile Court Act. So I was kind of, when I was preparing for this, I went back and reread it, and I said, oh, well, really, there's 2 aspects to this placement. One, the parent has to be found unfit, unable, or unwilling, or all of those. And the court also has to make a determination, well, if you're unfit, unable, or unwilling, we also have to make a finding that the health and safety of the child would be jeopardized if we kept them in the home with you. So it's really a 2-part test as I read the statute. Now, I will say, I've not had anybody argue that second prong to it, but it is there. And so that's an important thing to keep in mind. And I do know, and I know, I won't disclose the person who is associated with DCFS, but they agree that there are situations where if a parent is unfit, the child can remain in the home. So I guess I'm not the only one who thinks that, and that makes me feel good because sometimes I feel like I'm the only one who thinks a certain way. So so what's admissible is all evidence helpful in determining these questions, including oral and written reports, may be admitted and may be relied upon to the extent of probative value, even though not competent for the purposes of an adjudicatory hearing. So that's in 2-22. What does that mean? Well, it means about everything gets in unless it's not helpful. And it is not helpful in determining the questions. And what are the questions at the dispositional hearing? Do we take wardship? What do we do about placement? What do we do about services, right? If it's just being introduced just to trash the parent, it's probably not, it might get in, but it's not really contemplated as something that's evidence. So going on, so it's pretty liberal. And I will just leave it at that. I think we already all know that. Okay. So that's permanency go, might come up at the dispositional from time to time. What services will be delivered. These are the things that we're talking about. What's in the best interest of the minor, what's the proper disposition for the minor, what does the possible permanency go, what services will be delivered. Those are things that evidence is going to be introduced and directed towards that. Obviously, if there was a continuance under supervision, as we've talked about previously, that kind of blew up and ended up getting revoked, so to speak, then that's going to come into evidence as well at the dispositional hearing. So what typically is going to come in at a dispositional hearing, dispositional reports, or whatever they call them. I don't know what they call them in other jurisdictions. They refer to them as dispositional reports in most of the jurisdictions I've been in. Pertinent to the subject matter of the dispositional hearing. Sometimes you'll see a social history. You might see an integrated assessment. I didn't put that on my screen, but obviously you should see a service plan, but you don't always see that either. But reports specifically ordered by the court. I'll tell you one of the things that I do. Sometimes at adjudication, they find your client abused or neglected somebody, and you're like, I know they're going to order my client to do domestic violence, or I know they're going to order my client to do a psychological evaluation, or I know they're going to, whatever, treatment or drug alcohol assessment. So oftentimes I would say, Judge, you might as well order it now and order the DCFS pay for it, and let's get it going. And sometimes that report will be prepared before you get to dispo. Well, that would be admissible. So if you get a drug alcohol assessment that says, they smoke a little weed every now and then, but we don't see their need for treatment, then that's going to go in, and that can be considered. Obviously, if the court orders psychological, that's going to go in. So forth and so on. All other evidence that's relevant to the determination of the best interest of the minor. Those are the things that are admissible at the dispo. Right, and there's your order. At this point, I don't spend as much time on the jurisdictional because hopefully at this point we figured out who's in the case and who's not. But but you do have to make sure everyone has proper notice, and I've got at the top, you see I've got original and modified order. And I just do it that way because so often you get down the road in these juvenile court cases and we forget what's a dispositional order and what's not. And one of the classic areas that's not a dispositional order is the fitness of the parent. We were at a permanency review and we're like, well, we want to have a hearing whether the parent's unfit. Let's say they're fit and we want to have a hearing whether they're fit or unfit, whatever. That's actually a dispositional determination. That's not a permanency review determination. So as I read the statute, the rules of evidence for a dispositional will apply to that, and that you're entitled basically to a hearing as you would in a dispositional to make that determination. That's one example. There are other examples, guardianship, those kinds of things. Whether the worship would be terminated before closing, those are all issues that are dispositional, and so I've got modified. So technically what should be happening if you're having a fitness hearing or an unfitness hearing or a guardianship hearing or not, I'm not talking about the goal, but I'm changing guardianship, that kind of thing. Those are really technically dispositional hearings, and you would enter a modified order. That's why we did it the way we did it. I'm not optimistic that it will catch on, but that's how we did it. First of all, I've got about 11:30-ish. Is that about right? Yeah. I've had a couple of batteries die on me on my watches lately, and so I'm a little watch shy. So, of course, the first thing the court's going to decide, well, what's in the best interest of the minor? Is the mother fit, able, or willing? And we just kind of go through that through the order. The same with the fathers. Now, you'll notice on our orders, the fathers are always kind of last because we know there's usually one mother, but sometimes we have multiple fathers, and so we try to leave room for that possibility. And so that's why it's the way it is. That's why it's set up the way it is. And then, of course, guardians and legal custody and so forth. So we make fitness findings. We make, again, if the child has not been taken into shelter previously, that's always a possibility, again, at the dispositional hearing. So we have to make all the language gets into there in terms of whether that's an appropriate decision. And the service plan, which hopefully we have by now, and every jurisdiction does this differently. I've collected orders from all 3 different circuits, shall we say, maybe 4 or 5 different circuits actually, 5, and they're all different how they approach it. I will give you the parent's attorney's version, and understand that because it's the parent's attorney's version, it's least likely to be adopted. But as I read the statute, the way it's supposed to work is you have the service plan or case plan, whatever it's referred to, with the recommendations for services from Department of Children and Family Services. And the court, under the statute, is entitled to look at that service plan and determine whether or not to adopt those services for that case or reject them. If the court rejects the services that are recommended, the court can admonish them. I would really like to see a domestic violence. Now, the department, which is an independent branch of government, may decide, well, we don't agree and we're not going to recommend that service. That doesn't happen, but I'm saying it could happen. We have to understand the dynamic here is that we are dealing with separate branches of government. So DCFS may come and say, well, we've done our integrated assessment. We see no basis or reason for recommending that particular service, and so we're not going to recommend it, and you're not going to get a service plan from us that recommends it. That will happen about 1/1,000,000th of a times in the state of Illinois, but it can happen. But that's the way it's set up. And but what will usually happen is it will come back and say, you've persuaded us that we should recommend a domestic violence, and it will come back as a new service plan to be adopted by the court with that new service. So that's how the statute's set up. but that's not always how it works. And again, this is an area that is developing as to whether or not the court can make independent orders for services. My position, and it is a position, only a position, is that no, the court is not the expert. The court is not the one that has done the integrated assessment. The court is not really the one that has the expertise to decide what service should or should not be done. That's the province of the Department of Children and Family Services. Now, that they may not do a good job is a possibility, but I think generally they get it right most of the time. What the court can do, though, and what we see in the appellate decision is that when you get to determination hearings on progress and efforts, you see case law that says, well, they didn't comply with all the court's orders and the service plans and all that. Well, don't forget, the court can make orders. And those orders are typically orders of protection. So I would submit that really what we're talking about when we're talking about court orders, we're not talking about court-ordered services. We're talking about those kinds of court orders that say you're to notify us whenever somebody moves in with you. You're supposed to cooperate with the department. The kind of things that are really not services per se, but are kind of designed to facilitate that process. So that's what the statute says. I invite everybody to read the statute. If you disagree, let me know and why. But I think that's how it reads for me. Now, as a practical matter, in the way it works in our jurisdiction and a lot of jurisdictions, not all of them, some of them actually do follow this model. DCFS, you make the recommendations, we adopt them. But there are jurisdictions where everyone comes into court and says, I like to chime in. I think that this parent could use 5 drops a month, or could use more services and are being recommended by it. And everybody gets to chime in, and it all ends up in the order, and we end up with parents who are like, more is better, right? I don't think that's the way it was intended, but that's how it works. And for the most part, I think most people, and if you're a parent and if you're an attorney, you're representing a parent, and you think your client probably needs that service, it may not be something you would object to. So it works out, but just to be clear, that the statute is very different from how it's implemented from time to time. So the service plan is there. It's either appropriate or it's not appropriate. It may, and I've got in my orders, and I don't know if they kind of do carry over. I didn't include that. Okay. We do have a separate pages where these are mother's services, these are the father's services. There are 2 things we can do with that. One of them was we can say, okay, we're going to go ahead and do it like we've always done it. These are the services everybody thinks mom and dad need to do, and they have their separate orders and they know what they are. I like that in the sense that they've got it in front of them. They know what they need to do. The service plans are kind of long sometimes. It's hard to figure out really what they need to do and what they're supposed to do. So that's all helpful. But even if you adopt the statutory approach where you're adopting the court is adopting the service plan, there's nothing wrong with laying out what those services are in the court order as well. So these are the services that are part of this plan. And they are a court order once they're adopted. So I think it's okay to do that. And I think it gives clarity to the parents as well to have it kind of laid out that way. So we do provide for that. I don't have that on this particular handout, but we do provide for that from time to time. All right, I don't know if guess I got to do permissive reviews, and then we're having the filet mignon. Okay. All right. Again, we're at dispo, paternity. Hopefully we dealt with that. But if the father is still there, let's make sure we invite him. Indian Child Welfare Act still applies in terms of placements. And again, we have an opportunity to revisit the issue of visitation. I have developed a visitation order. That's a separate order. I think that the juvenile courts are probably a little reluctant. Some jurisdictions do have visitation orders, some don't. Some of them that don't are reluctant to do it because it's just another order. But I think it's a good thing to have a visitation order. Say this is what the court thinks is the minimum amount of visitation that a person should have, a parent should have, and kind of lay it out. Times, the frequency, the duration, the conditions, all in accordance with, and we have to go back to 210, right? That's the shelter care section to figure out what all the criteria we're going to be looking at and making that determination. But I think it's not a bad idea to have a visitation order. If there's already one in place, then the court will simply just continue it on or modify it or however. I guess I've got to keep up here. So J is my password. Got myself lost, you know. Yeah, visitation, J. Okay, so again, same with orders of protection. If you had some outstanding orders of protection, a lot of them will expire at the dispo or at adjudication. That needs to be addressed one way or the other, particularly if there's prohibitory language and your client's done a lot of things. So often it's sort of like, well, dad can't be in the home. That's the original order of protection or part of a safety plan or whatever. But your client's now done a bunch of services, and in fact, the courts found your client fit, didn't find him unfit. You know, you may want to make sure there's no prohibitions in the court orders that they can be pointed to prevent that from happening. So I'd like to see Illinois kind of start having a visitation order in all the juvenile courts. That way it's front and center and everybody knows it's there. The other thing, and I'll mention about the dispositional order, is that just making sure that we set the next permanency hearing and we set it within appropriate time frames. I think we all know that, but that needs to be something happen. I'd like to put in here, again, every jurisdiction does it differently. We get permanency review reports, right? How did the parent do, you know, kind of reporting on the parent. The two things I will say about that. First of all, the statute does allow and the court to require that those be sworn to. So if you get a permanency review report, I'm drying up, it can be sworn to. The court can require that it be sworn to. It doesn't happen, but it can be something court orders. Number one. Number two, they are, when we get the permanency reviews, we know that the caseworker has to be there, you know, and all that stuff. So I think at least implicit in the statute, I think that there is to be a report, and we should get it in a timely fashion. So I have included an M language that they would provide it 14 days before the review. That's really optimistic, but it's a starting point. I don't think it's not patently unreasonable because it's 6 months out, you know. But getting it the day of, has anybody gotten it the day of or the day before or over the weekend? Yeah. How does that? And as a parent's attorney, you're in, you know, I don't really want to ask for a continuance. You know, I don't want to. You know, it's just very awkward for a parent's attorney because, you know, you really don't have time to talk to your client. Was this true? You know, did you really do that? You know, or, oh, I didn't know that you had completed your counseling. If I'd known that, I would have filed a motion to have you found fit. Or, you know, you get into these really bad situations. So I think that it's good to have something in the order that obligates that report to be filed in a timely fashion. Now, I'm not saying they can't come in with an addendum. Okay, something happened Thursday before the review. That's understandable. But getting something to us 1 or 2 days ahead of time, that's just, we wouldn't allow it in any other court proceeding. As attorneys, we would never allow that. But we kind of have to tolerate a lot of it. So it's in there. And of course, at the dispo, what is the dispo? It's your final order. That's your final order. And that's the appealable order. So making sure that that's in there and that they've been advised of their appeal rights. And so on. Permanency reviews. Well, it might come as a surprise, but that's where permanency goals are set. And they're set in the best interest of the child. And they review the placement status of the parent. So that's pretty much what you do. Believe it or not, there's a case that says permanency hearings do not concern themselves with the issue of parental unfitness. So that might come as a surprise. That's where I'm not pulling the stuff out of thin air. I'm just, that's why it's a dispositional matter. That's not to say they can't be combined. You can't deal with them together as long as you know you're doing that. The other thing with a permanency review, of course, the orders are not final orders. If you want to appeal something, you have to take it up interlocutorily. And then the other thing that the court does at the permanency review hearing is the court determines whether the parents or guardian or custodian have made reasonable efforts and whether the agency has made reasonable efforts. Now, since I do have the podium, I get to complain a little. But typically, we focus a lot on the reasonable efforts of the parent. And we always focus as much as the reasonable efforts of the agency or the department. And, like we were talking about, you get a report 1 day before your hearing, or they miss information, or they are inaccurately report information. As a parent's attorney, you really want, it's frustrating because I'd had situations where if my client says something and it's inaccurate, then they haven't made reasonable efforts. But if there's something inaccurately reported, we all make mistakes. So I'm just anecdotally, that is kind of what happens. But it is not exclusively the parent's review. And that's the thing that gets lost. We're just not looking at the parents. We are looking as much at the agency and their efforts as we are at the parents. They are the guardian. They're the ones who are setting the services. They're the ones who are facilitating this whole process at the lower levels. And if they're not doing a good job, then they are to be held accountable. But those are the things that we deal with at the permanency review. Surprisingly, I have not been able to find any evidence that there's any burden of proof at a permanency review. I think it's essentially what it is. We're just reviewing, seeing how things are going. Nobody's proving anything. Nobody's unproving anything. So far, I've not come across a case. But if you have one, I would love to get it, and I would cite it in the future. The Illinois Rules of Evidence, of course, apply all throughout these proceedings, as does the Rule 218. But in the case of permanency reviews, 228 is the operable evidentiary language that allows all evidence, including oral and written reports, helpful to reviewing the permanency goal, the placement status, and the placement goal of the child. Some courts say that have said that the evidentiary rules that apply to the dispositional hearing also apply to the permanency review hearings. At the risk of sounding arrogant or erudite, that actually is inaccurate. The case law says that, but the statute does not. The statute has its own sections. Again, and I've just cited it to you, it's up there somewhere, 228. That's the section that applies, and it's different language than the language under the dispositional. And there's a reason for that, is that there's different things going on. There are different proceedings in terms of what's going on. So there's a tendency to kind of mush everything, to conflate everything and make it all together, but there are very separate language, separate rules. So when you're looking at the rules of evidence in the permanency review, you're looking what's admissible, what applies is what's relevant to that particular proceeding, not just everything. Again, for what it's worth, you know, the rules of evidence still ought to apply because they still refer to it as evidence. You know, they don't refer to it as information. If I think the legislature intended for just everything and anything to come in, they would just say any information that's helpful gets in, but they use the terminology evidence. And I stole that idea from a dissent and an appellate case that really wasn't front and center in terms of the issues, but that the use of the word evidence suggests that the rules of evidence still apply even in a permanency review hearing. And so while what's admissible may be very expansive, you still would have an opportunity to object on whatever grounds you think you can object. And so I wouldn't remind everybody to object if they think there's something coming in. We get a lot of police reports at permanency reviews, which I find very objectionable. There's nothing, I can't find anywhere, it may be helpful, but it's hearsay and it's in contradiction to the Illinois Supreme Court rules. Direct contravention of that. So we have a constitutional impasse in terms of what the legislature thinks is allowable and what the Supreme Court thinks is allowable. But that has yet to be decided fully and completely. How are we doing? 8 minutes? Okay. So we're looking at very specific things in the permanency, the appropriateness of the services delivered, the reasonable efforts of the parent or agency. You know, the permanency report's going to get in. We already talked about that. A lot of times parenting assessment reports will come in if they're pertinent to the subject matter. Again, reports specifically ordered by the court, a psychological evaluation would get in. And other evidence allowed by the Juvenile Court Act would be admissible. And there's your permanency review order, pretty straightforward. What's your goal? I hope everyone knows what the goals are. Is everyone familiar? I guess I can't see webland. But we all know their goals. There's return home goals, or remain home. Well, the continuum is remain home, return home within 5 months, return home within a year, return home pending court status, subsidized guardianship, termination, and so forth. So there are a variety of goals. Every county, every jurisdiction refers to the goals differently. We go by the DCFS regulatory numbers. So we go 21, 22, 23, 24. Other jurisdictions use different language or different numbering systems or whatever to refer to the goals, but they have to be set forth in your permanency review order. So we provide for that. There again, if there are new services that are being recommended, I'm kind of on the fence of whether or not that's a dispositional request or whether it's a permanency review request, because it's something new. We're not reviewing it, you're just recommending something differently. But anyhow, you have your current goal and then your projected goal, whether the child can continue in placement, whether the parents have made efforts, reasonable efforts, whether the departments have made reasonable efforts. Those are all things that need to be addressed in the permanency review order, which I think kind of gets us really, really close to where I need to be. Is this a good place to?
Sure. Do you want to ask 30 questions before we have a few minutes, or do you want to just?
Well, we got what? How long we got? 6 minutes.
6 minutes.
Okay, 6 minutes for questions. Everyone's still awake, more or less.
loop off something you said earlier. If a permanency, if you're having what's nominally a permanency hearing, but the agency has brought forth, or the service plan you're addressing has tasks in it that are different or new since the disposition, that could be arguably that's a new disposition as opposed to a permanency hearing.
Will you repeat the question so that we
Like,
can
explore that question.
Well, this is a takeoff from my ill-advised comment that, you know, a new service could be considered a new dispositional, a dispositional determination. And whether or not, if a new service is recommended and ordered, whether that's a new dispositional hearing. My guess is that it will not be treated like that, but certainly it's not something within the purview of a permanency review in terms of the review aspect of that hearing. But it, you know, it's something that could be argued in the future, that if you found my client unfit and you ordered them to do 2 new services, that sounds and quacks like a duck. You know, it probably is a duck, and it probably is a dispositional order,
Well, it
as
kind of
opposed to a
fits-
review order.
Fits in with the requirement you have to have in the order, the disposition order, specifically what's, you know, why are you finding them unfit or unable? And if
Well, that's the
case, and then
adjudicatory order.
6 months, exactly, and then 6 months or 7 months later, the court and or DCFS is now saying, well, here's another reason why they're unfit or unable. I guess
Well,
be a tool for getting these permanency hearings to be more easily reviewed as well.
well, a couple things I'll say. First of all, the case law allows the juvenile court to come to the realization that there are additional problems than what might initially have been discovered with a parent or a family or whatever. And so there is provision in the case law that we can take that into consideration. And I think we all understand that to some degree that makes sense, right? You know, didn't know he was a heroin addict. I guess now that he's dropping, we've discovered that, and that's a problem. And so the court is entitled to acknowledge that that's going on, and presumably, I think at least implicitly, entitled to react to it. The question really is, how do we characterize that reaction? Is that a review? Would that fall within the purview of a permanency review, or does that fall within, or is that a new dispositional determination in terms of a new service that's ordered? Now, obviously, if they find them, my position, I think, is a clear position that if you have a fit parent and you're filing a motion to find them unfit, I think that is clearly a dispositional determination. You know, because there are a lot more ramifications to that. Ordering a service might fall somewhere in between, and whether or not the appellate courts will acknowledge that it's a dispositional determination and give you a right to appeal from that, I'm not optimistic about that either. But I'm just and you have the navigating the juvenile court labyrinth, and you can see it's pretty extensive. And I've looked at a variety of resources, and I have to say that what I tried to do when I started doing that is I was trying to figure out, how does this thing work? You know, my first experience was up in Henry County, Cambridge, Illinois, and I was objecting to everything. You know, everything was hearsay. What's going on here? You know, I was a new kid out of law school, and I went back and I said, I got to figure out what's going on here. Everything's going to evidence. You know, are there any rules here? And I went to I won't mention their names. I went to various resources, and they were not particularly helpful to me in understanding what was going on. And so what I've tried to do is try to bring some meaning to all this. Now, the thing is that these are areas, this is a basics training, so we're kind of in a more complex area when we're talking about what's dispositional, what's not. But the simple answer is that the statute gives us some limited guidance, but there's really not a lot of answers. There are more questions in this statute than there are answers. And part of it is just the way it's evolved, and part of it is just the nature of what we're dealing with. So, any other questions? Or is that...
One question on the webcast. Is there any benefit to asking asking the judge for a finding that DCFS has not made reasonable efforts at the permanency review. What recourse might be had for that?
Is there any benefit to asking the judge?
To find DCFS has made no reasonable efforts.
Sure. Well, benefit to whom? There's a benefit to the parent because if the parent is not doing very well, it could be because they haven't made their reasonable efforts. In other words, you know, if the parent didn't get the counseling done because the referral wasn't made in a timely fashion, it's a little disingenuous to suggest that they didn't make reasonable efforts. So I think directly, yes, it will benefit the parent to have that reasonable efforts, no reasonable efforts finding. Most of the times we kind of shy away from it because there's some funding attached to that, you know. So we tend to shy away from making that request. But yeah, it's important. And when we get to the termination part of this program, we'll talk about the 9 months for reasonable efforts and 9 months for reasonable progress. And, you know, as parents attorneys, we're always looking for an excuse, you know, it's, yeah. And that there's no better excuse than saying, well, you didn't do your job. And that's why I stress the permanency review is almost as important. The finding of efforts for the agency is almost as important or more important than the finding for the parents' efforts. Because if they're not doing what they need to do, we already know that the parents are going to make efforts if they're not stepping up and doing what they need to do. And one of the things we run into a lot as parents attorneys is slow referrals. And there's some economic reasons for that. And I'll be happy to talk to you off the record. No. So we do have that problem. So I think we're kind of at lunchtime.
Yeah.
All right. Thank you. And we are. Do you want to?
The webcast notice will be resuming at 1.
We will be resuming at 1 o'clock Central Daylight Standard Time. Okay. Bye. Thank you.
Hey, we're back. Take it away.
Welcome back. Okay. All right. Okay, so starting out this afternoon, I'm going to we've talked a lot about the juvenile, the wardship proceeding. There are a couple questions I'm going to address. One of them was the difference between unfitness in the wardship proceeding and unfitness under the Adoption Act. The biggest difference is that one of them you're more likely to be terminated on than the other. I refer to the unfitness, and I've used them interchangeably, but I refer to unfitness as really dispositional unfitness, and that is essentially not been fully defined, I guess is the short answer. There's not a definition of unfitness in the wardship proceeding. The two most common definitions have been one, that the parent lacks minimum parenting ability, which is derived in part from the administrative rules. It was how the DCFS defines unfitness. Some courts have defined unfitness as the inability to have the child return to the care of the parent. That those are two sort of hallmarks of unfitness at the wardship level. So having said that, we don't have a lot of guidance from the statute or really even from case law as to what really it means and how we can tell when a parent is fit or unfit. So that's something we would probably want to work on as parents attorneys to try to get a better definition so that we have some uniformity in its application throughout the state of Illinois rather than sort of random decisions in that regard. Under the Adoption Act, unfitness is more clearly defined because the Adoption Act tells you exactly what it is that will render you unfit. And we'll get into that a little later, but there are any number of things that are listed under the Adoption Act, such as depravity, habitual drunkenness, if you're a certain kind of a criminal, have engaged in a certain kind of criminal activity, or if you are mentally incapacitated in such a way that you can't parent in the foreseeable future. Those are all things that are clearly set out under the Adoption Act that tell us what constitutes unfitness for that purposes, and I would just refer you to the Adoption Act for those definitions. The other question that has come up is there a difference between the best interest factors in the under the wardship proceeding and under a termination case? And that's a little more complicated of an answer, a question. The best interest factors are laid out in the Juvenile Court Act under Section 1-3 and Section 4.05, and it lays out A through J of all the different factors that the court would look at for in considering the best interest of the minor. So that statute doesn't change. You know, those factors are the same factors that are best interest factors, but there are other considerations that will come up at the adoption best interest hearing that we would add to this list of factors. And I'll address that as we get closer to that particular topic. I would also add that there is, even though generally, I think the general convention is to look at the Juvenile Court Act's best interest factors, which I just indicated, I think it was Section 1-3 of the Juvenile Court Act. There are best interest factors that are laid out in the Adoption Act as well, as they relate to the adoptions. And they are very similar to the ones that we have in the Juvenile Court Act, but not identical. And it's not, again, depending on how you read the statutes and whether you read them together, they may be in addition to or supplemental to or simply stand on their own. So I'm going to spend just a little bit of time here talking about the, so we've gone through the temporary shelter care, we've gone through the adjudication, the dispositional hearing, we've gone through permanency reviews, and the parent or guardian or custodian has not done what they needed to do, or failed in some respect, or has some character flaws that are insurmountable, and the state has filed a supplemental petition or a separate petition to terminate the parent's rights pursuant to the Adoption Act. And there again, that's where it kind of gets started. We do require, it's not something that, unless it's an expedited termination, which can happen within the Juvenile Court Act, typically you're going to see something come up later on down the road if the parent's not complying with services or just not getting it. So we get the termination proceedings. The first thing that's important to know, and that we all, I think, know who have practiced in this area for a while, is that the parent's right to their children is a fundamental liberty right. And so what that essentially means is that that they have a right, obviously, to notice of the proceeding, and the U.S. Supreme Court has decided that we're not going to allow these proceedings to operate under the preponderance of the evidence standard that the wardship proceeding goes under, but we're going to require a heightened burden of proof, which is the clear and convincing evidence burden of proof. Again, again, important is knowing whether your client is Native American or eligible to be registered as a Native American, is that in order to terminate on a Native American, you will have to prove beyond a reasonable doubt that they are unfit. So that's an important thing to know. So as I spoke of earlier, there are multiple grounds in the Adoption Act for the termination of parental rights. I'm not going to enumerate all of them. I'm not an expert on all of them. Frankly, I've only dealt with about 5 of the 15 of them that there are, and I think most practices in the area deal with generally the same group of them, but there are several of them. And there are actually a couple that are unconstitutional now, but are still in the statute. But there are several grounds, and they're all listed in the Adoption Act under Section 1D of the Adoption Act. The first thing we need to know, besides the fact that the clear and convincing evidence is the burden of proof, we will know that in order, if there are multiple grounds for alleging unfitness, the state only needs to succeed on one ground. So they can fail on 2 of them and win on 1, and you're going to be found unfit. So there's no reason, so that's important to know. So you really can't ignore any of the grounds that are alleged. As a parent's attorney, you have to address all of them and be prepared to defend against all of them. The other thing, important thing to know about the termination proceedings is that you cannot be terminated for a ground that is not alleged in the petition, which seems pretty elementary, but it does happen, and so be aware of that. You probably, if it's a no-fault dependency petition that you're coming into it with, you're probably not going to be able to have your rights terminated in a no-fault dependency case, which is unlikely to happen anyhow, but I'm just telling you what the case law provides. So the rules of evidence in the unfitness phase of the termination proceeding, and what I mean by that is that it's a bifurcated process for terminating parental rights. The first step is to find the parent unfit under the Adoption Act. Step 1. If that happens and the court determines that the parent is unfit, the next step is to have what's called a best interest hearing. And at that best interest hearing, different things are taken into consideration. If the court concludes at the end of that it's in the best interest of the child to have the parent's rights terminated, then that's when the termination occurs. So that's the important thing. So I don't know how to refer to the first phase. I refer to it as the unfitness hearing, but some people refer to it as the adjudicatory hearing, simply because we're familiar with that terminology. But however it's referred to, and whatever the jurisdiction, whatever that phase is that they're finding the parent unfit, that's what I'm going to be talking about here a little bit. And probably the most, so I think I've already mentioned that because there's a fundamental right in here, we already know the burden of proof is higher. We already know that there has to be notice given. And there are certain times that the court can't really terminate. And for example, there's certain reasons the court can't terminate, and I'll get to some of that. But let me talk a little bit about probably the most common ground for finding a parent unfit in the juvenile court, adoption, those related cases, are going to be failure to make reasonable efforts or failure to make reasonable progress during a 9-month period. And that typically arises from the fact that the parent or former guardian or whatever has not completed services or has been not diligent in completing services, or did services but got nothing out of it. And so there's a conclusion that they didn't make reasonable efforts, and so the state or the petitioner, I guess anybody could file a petition under the Adoption Act, would file a petition seeking to terminate the parental rights of that person. And the Juvenile Court Act allows for the state's attorney to file a petition to terminate under any other grounds that are listed under the Adoption Act, which is nice, except that most of them have nothing to do with the Juvenile Court Act, but it does allow it. The most common was reasonable efforts, reasonable progress, whereby the state will select a 9-month period where they believe that the parent has not made reasonable efforts or made reasonable progress towards the reunification with the family. And if they are successful, obviously they will be found unfit under those grounds. The important thing to know about that particular ground is when that 9-month period can start. And somewhat counterintuitively, it doesn't start from the date of disposition. It will start from the date of the adjudication. So they literally could start from the adjudication, and then 9 months out from that would be their first opportunity to file a petition seeking to terminate or find a parent unfit under that particular ground, efforts or progress. That's the 1DM section of the Adoption Act. So that's important to know. It seems a little counterintuitive because sometimes you don't know what your services are or what your court order to do till you're dispositional. So in some respects, you do end up with a fairly shorter than 9 months period. The appellate courts are a little unsure about whether or not you're guaranteed a 9-month period. In other words, that it cannot be filed before the 9-month period is over. Efforts have happened where there's been a 7 months and something's been filed and they've already jumped the gun, and some of those have gotten a pass, some of them have not. So that's a little bit up in the air. Obviously, as a parent's attorney, it seems to me 9 months is not that long, and surely you could wait a couple more months or so. I have had cases and not had great success, but where the services were not referred in a timely fashion. We got the court orders. We didn't get services referred till 4.5 months into the initial 9-month period. And I had other problems with these cases, which might explain why I wasn't successful. But I did argue. I said, we ought to get 9 months. If you only get to do your services 4.5 months, you really can't gauge how somebody's doing. So just food for thought that, what did the legislature intend? I assume they intended, based on the fact that the service plans are due within a certain period of time and all that you would get the benefit of the full 9 months. Your services would be in place. You would be able to do them and be successful easily within a 9-month period. So just food for thought. The other thing is, and here I'm just kind of shooting from the hip a little bit, but it's been my experience anyhow that reasonable efforts or reasonable progress does not always correlate to having had to do 100% of your services during that 9-month period, particularly your first 9-month period. It's quite often the case that not everything can be done in 9 months. Sometimes individual counseling can take a little longer than 9 months. Sometimes even substance abuse treatment can take a little longer, depending on which kind you're doing. So it's more about the efforts. It's more about, are they making the efforts, which is really hard for the state to win those because our clients usually make enough efforts. But progress, are they making any progress too? And that's why I said earlier that it's quite possible sometimes that your clients have done all the services but not learned anything from them. It doesn't do it's not very convincing to the court if your client's done domestic violence classes and then 2 months later, the person who perpetrated the violence is moving back in along with two other buddies who've done the same kind of thing to other people. So as a parent's attorney, I don't think it's our job to be ignorant and naive, but be aware that these are possibilities and make sure that our clients know that. So as far as, and I'll just throw out, just in case nobody knew, and I'm not sure that it's that important, but the court cannot terminate a father's rights based solely on the fact that the father failed to register with the putative father registry. Just throwing that out. It doesn't happen very often, but it can. The other thing that might be important to know is that, and I've run into this, and I'm sure some of you have, is, well, my client's a parent, but she's 16 years old. How, that doesn't seem right. Well, the bad news is that you can terminate on a 16-year-old parent. And so that's important to know too, right? You had a kid, you got to tell your client, hey, you had the kid, whether you like it or not, your parent and the rules of parenthood and adulthood are going to apply. You're not going to get a pass. You got to do the services. You got to get it together. Also, believe it or not, it's not necessary that the child had been removed from the home before the termination can proceed. In other words, being in substitute care. The child could be in the home, and they could still file a petition to terminate. So that's not a prerequisite. So those are things that kind of know. They don't come up very often. It really depends on the jurisdiction and how that your particular jurisdiction treats a parent who's found dispositionally unfit. Some of them will allow the child to be in the home. Some of them think that they can't be in the home. So depending on your jurisdiction, that would be relevant. Many of the jurisdictions I've been in, it doesn't apply. So we have a bifurcated proceeding, and we're doing the unfitness. And so there are any number of issues. The other issue I will point out is that, and this all seems fairly elementary, but it does come up, and there are cases that talk about it, and that is that an unborn child cannot be included in the same 9-month period as a previously born child. So if the kids, if you're going to terminate somebody for failure to make reasonable efforts or progress during a 9-month period, if you got another kid that comes along, you can't just throw them on the pile and say, well, let's save time and effort. That kid gets their own 9-month period. It has happened, and it has gone up on appeal to the Illinois Supreme Court. So just pointing that out. From an evidentiary point of view, the rules of evidence for civil procedure apply. It pains me to say it, but thanks to me, the Juvenile Court Act applies. 218 has been applied, at least in the 3rd District, to adoption proceeding, which means that Section 218 can be looked at. Now, I still disagree with that, and I found multiple reasons why that cannot be the case, but I don't have a panel, and I don't have any authority to say otherwise, but I don't believe that there are some problems. And but I will say that determination using the business records, a couple things. First of all, if you look at the language of Section 218, it says that it applies to abuse and neglect proceedings. The termination case is not an abuse and neglect proceeding. So I'm just throwing this out there for those of you who like to do appeals. And so I don't believe it applies, but I will say that there's case law that says it does. There are any other number of reasons. The Adoption Act has its own evidentiary provisions that I guess we're supposed to ignore totally. So there are a variety of reasons for not, as a parent's attorney, arguing against 218 applying, but for our purposes now, at least in the 3rd District, it's going to apply. And since the appellate decisions are applicable throughout the state of Illinois, it applies everywhere else until another district enters an order to the contrary. But what I can say with some authority is that a petition to terminate must be based solely on the evidence that's presented during the termination hearing. So if it's not presented at that hearing, it cannot be considered by the court for termination. And as I've said before, if you have a Native American, now you're dealing with beyond a reasonable doubt, burden of proof. So Section 20 is, I don't know if this goes in. All right. So Section 20 of the Adoption Act is the section that talks about practice. It's the one that tells you that the provisions of the civil practice law apply and shall apply to all adoption proceedings except as otherwise specifically provided in this act. So it doesn't provide explicitly anywhere else in the act that 218 will apply, but we can just gloss over that and just pretend the express language is meaningless. Section 2.1, and this is really what's been used to argue that 218 applies, is that Section 2.1 of the Adoption Act provides that it shall be construed in concert with the Juvenile Court Act and other child-related statutes. And on that basis, the rules of evidence from the Juvenile Court Act 218, I thought no tornado, okay. Rules under Juvenile Court are incorporated into the Adoption Act. That's in Ray Yasmin P. That's probably in your materials. And I will not belabor my disagreement with that, but just say, again, the plain language of the statute seems to contradict that determination. I don't think that they're really not, they're very different statutes. One of them is designed for the reunification of family to try to get the parents able to parent. The other one has given up on it. Basically, we're saying there's no reunification here. We're adios. This is the end of the road. So from construing them together is no small feat, because they have very different policies behind them. And because there are different policies, how relaxed your rules of evidence are going to be as to one versus the other make a difference. If your policy is that we're all going to work together, we're going to try to keep this family together if we can, then we're going to make it easier for people to introduce information to the court to enable us to make good decisions and do that right. But when you get to a termination, that's an adversarial proceeding. There's no in between. There's no, can we be friends after this? It's like breaking up and say, well, can we be friends? It's not going to happen. That's the end of the road. So I don't really know what we're construing together other than, what we can. So in any event, what's admissible? Evidence that's relevant to the allegation. So whatever the grounds are that are set forth in the petition, like I said, there's depravity grounds, there's reasonable efforts, reasonable progress, mental health, so forth and so on. All those different grounds. Whatever's laid out there, it's going to be relevant to put that in. So if you need to have a certified conviction, that's going to go into evidence. Probably failure to complete a treatment program, that's going to go into evidence. The other thing I will say before I go any further here is, and I always go back to the reasonable efforts and reasonable progress, because I don't know about other jurisdictions, but that tends to be probably 60 to 70% of the time that we have a termination. That's usually the allegation. And that makes sense because it's coming out of a juvenile court wardship proceeding where services have been ordered. You typically are going to see that. So, I'm losing my train of thought. So the thing there is that the 9 months is a pretty critical thing, right? So when you get the petition to terminate, would be nice to know what 9 months they're talking about. The good news is that there is some case authority that says that they're required to specify the 9-month period. So if it's not specified, you know, and you proceed without knowing what the 9-month period is, you may want to call up your professional liability insurance company, you know, the next day, because you could run into some problems. So at minimum, if it's not specified, probably the best approach is to do a bill of particulars, or maybe even do some discovery. And this is the thing that people find kind of surprising, is that, believe it or not, you can do all those things. These are civil cases. You can do discovery, you can file motions, you can do all kinds of things. Now, a lot discovery in any case is discretionary with the court, obviously, but the court's going to have to make a pretty good explanation why you can't do any discovery, or why they won't grant a required bill of particulars, or that sort of thing. And I think from a due process, particularly when you get to the termination proceeding, there are going to be some very big problems in denying that. So at least try to figure out what the 9-month period that we're looking at. Again, still on the 9 months issue, the statute's kind of unclear to me as to whether or not it's supposed to be 9 months sequentially. It doesn't say, but in practice, it's not uncommon to see 9-month periods get straddled. So you might have your initial 9-month period. They might pick up at month 4, you know, through month 15 or whatever. You know, my math might be off there. So, question.
There's a question from
Yeah, so if the petition has 3 separate 9-month periods, and presumably the dates are set out in the petition, then now you know what your 9-month periods are. And you have to defend them, just as if they're 3 separate grounds. Yeah, I mean, you know, in wishful thinking is that you would say, well, the statute says only a 9-month period, and you can't do 3 of them. But I don't think you're going to be very successful with that. I think you're going to find that, you know, if they got 3 9 months. Now, the big question is, looking at the last 9-month period, that might make sense. What about the first 2 months period? Why did we wait 18 months to file the last 9-month period? And I have tried with no success so far. And it hasn't been addressed, so it hasn't been ruled out, the idea of laches in certain cases. You know, it is a civil proceeding, but laches still applies in these cases, in my opinion. I don't see a reason why it wouldn't. So if you're going to wait 18 months to file a termination petition based on the first, you know, and again, this is all fact specific, then you might want to look at that and consider that as a possible affirmative defense, or something of that nature. But it does make you wonder, you know, why 3 periods? Because they would probably be. Now, the problem you run into, and this is a problem with the legislation, and it's not a problem for the state's attorney, and I appreciate that, and it's not their fault, but it's a real problem for parents, because it really invites abuse, in the sense that, well, you literally probably could pick a week apart 9 months periods, you know, so, you know, from January 1st through September 1st, and then January 7th through September 7th, and you could have this whole, and it doesn't happen like that all the time, but it could be abused. And I think we need to look at this statute and figure out a way to make it fair for the prosecution, but also fair for parents, to where it's not so open-ended that virtually anything can happen. But that's a long-winded answer to, I think, the question of what if there's 3 separate 9-month periods that are alleged. For our purposes, for now, we're going to defend each and every one of them, but we may ask the question, why'd you wait? So the evidence that's going to be relevant, obviously, is those allegations we just talked about. And for now, whatever would be admissible under Section 218 of the Juvenile Court Act. I will point out that if your client has pled guilty to something, that will be admissible. And that's just the way it is. Certainly, if it's admissible if it's relevant. So for example, a depravity count. Otherwise, it may not be admissible if it's just intended just to prejudice the court or just throw something against the wall and hope that it sticks. So I just realized I don't really have an order for you, do I? I think we use our adjudicatory order for our termination, so I would just refer you back to that. Probably better practice would be to have a separate, order for your terminations, but the county's paying for some of this stuff, so we try to double up on orders if we can. So we're now at the best interest hearing. The parent's been found unfit. You only get there if the parent's found unfit, and under the Adoption Act. And we are now no longer looking at it from the parent's eyes, but we're looking at it from the child's eyes. What's in the best interest of the child? And like many proceedings, this is the preponderance of the evidence is the burden of proof at this proceeding, as opposed to clear and convincing at the previous one. And as with all the previous proceedings, the rules of evidence, civil procedure apply. The moral rules of civil evidence apply. And in this case, Section 218 would apply, as well as Section 222, the dispositional kind of evidentiary admissibility and standards. In order to, in making its determination of that it's in the best interest of the child or not in the best interest of the child to terminate the parent's rights, the court is required to consider the factors that are set out in the statute. And we talked about those factors. Again, most of the time, in most places, we're looking at those factors that are set out as best interest factors in under the definitional section 1-3 of the Juvenile Court Act, which has the best interest factors, and it lays out quite a few of them. And so, it's always a good idea for the court to go through that and for you to listen very carefully to make sure that those factors are being addressed and properly considered. They range from, physical safety and welfare of the child's background and ties, including the familial and cultural and religious background and child's need for permanence, including the child's need for stability and continuity and parental figures and so forth and so on. Typically in a best interest hearing, it's the familial ties that take center stage. Sometimes, and I've learned recently that the request should be for a bonding attachment, not a bonding assessment, but an attachment assessment, not a bonding assessment. And to determine whether or not the child has some kind of attachment or some relationship with the parent, because that is one of the factors that would be considered. So the court would be required basically to go through these factors. You would have an order that would essentially lay out that they considered the factors, hopefully on the transcript. I considered this factor in favor of this or in favor of that. And if the court determines it's in the best interest, then the court obviously, by preponderance of the evidence, following those statutory factors, would conclude that one way or the other. The difference between the best interest hearing and best interest determinations in the wardship proceeding are that when you get to the best interest hearing, the court can consider the substantial completion of court-ordered services on the part of the parent as weighing into that determination. And that's, it should be, I'll give you the In Re CW, it's citing In Re DL at 191 Illinois 2nd 1. And also In Re DA 222 ILAP 3rd 73. So there is case authority that, you know, if you get to the best interest hearing and your client, your parent, whatever, has essentially completed their services, you know, and, you know, there's a good chance that the child could be returned home, then that can be considered by the court. And you should try to introduce that information to the court.
And you're saying can be, not must be?
Doesn't have to be, but,
Thank you.
you know, it's not, well, it must be. I mean, if from a professional point of view, if you're representing a parent and you have that information, you better try to put it into evidence, you know. Yeah, but the court's going to give whatever weight to it that it would give to any of the factors. But the court, and they may ignore it, but they can ignore other things too, and that doesn't always work out too well. So
Liz, another question from the webcast.
yes,
So repeat
what-
that for the, sorry. They can't hear me.
so the question is, can you ask for a bonding assessment for best interest? And the answer is yes, you can ask for that. The recommendation nowadays is that you ask for an attachment assessment. It's a different type of an assessment, but it's a more accurate for the purposes of a best interest hearing. And there is some authority for that bonding assessments can be taken into consideration at the best interest hearing. I can't say that the court is required to order it, but the court, then it puts the courts in an awkward position of saying, well, I have to consider the best interest factors, but I have no clue whether or not there's an attachment between the child. You know, I don't know how you consider that factor unilaterally, you know, without that additional information from a professional. So it seems like a fair request and has not been rejected.
Recently, we have the caseworker and the CASA filing in a best interest report. And in the best interest report, there is no reference to the parents. It's, I've been to the foster home and everything is hunky-dory. Any case law about the fact that that is sort of not including everything about the child?
No, well,
So repeat the question for the.
so the question is that you get a best interest report, and there's a lot in the report about the foster parent, but there's nothing in the report, or virtually nothing in the report, concerning the biological parent or the legal parent. Or is that what the
Yes.
question was?
Yes.
And is there any case law that addresses that? At this point, I'm not aware of any. I will say that, you know, again, the statutory factors dictate that there be some information along those lines. So the problem that how you might address that is you might say, well, you might do it through your question. I mean, you can still call your client and you can still ask your client, well, how do you get along with your kids? You know, how do visits go? And, you know, and try to fill in the blanks that weren't filled in. There's nothing to prevent you from doing that. And unfortunately, there's not reasonable efforts findings at best interest hearings. Otherwise, you'd probably ask for that too. But probably the best approach would be to simply ask for a continuance and ask that it be completed in such a way that, you know, we would have that information, which of course would ensure that you would only get glowing and positive information at the next report. So, but no, I don't have case law on that at this point.
We had at one of our seminars where we were talking about mental health exams and what have you, family strength exams, we said if you can't identify at least one strength in the family or the parent, then it's not a complete report.
So,
Something.
so you had a situation where they didn't identify at least one strength for the family?
Oh,
then
yeah,
it was-
anytime I've ever gotten a report where they don't identify a single strength in the family unit or the parent, any of the parents, I always point that out.
Right, so basically
Everybody's got at least some strengths.
the principle is that if it doesn't contain some positive information, and may not be entirely, it may be self-impeaching, in other words, it might not,
That's what I would argue.
it might not have been a good faith report. And I don't have authority for that either, but certainly it makes sense. But there are occasions, I think we would all admit, where there aren't very many positive things to be found. But there are equal number or more occasions where there are a lot of positive things that are never reported. And one of the things I would suggest that I found is that often the best interest reports are prepared with an eye towards litigation. Now they're going to be admissible in anticipation of litigation, in anticipation of the best interest. So everybody knows who's preparing this report what the objective of that best interest in hearing is, and to the degree that there are, depending on the professionalism of the people preparing the report, sometimes that report is prepared in a way that is going to support the conclusion or the recommendation in that report. What I have found helpful for me, and it takes some work, is sometimes it helps to go back to the old permanency review reports and see what the reports are about the visits in those reports, what the reports are about, generally how they're doing, how they're interacting, not just with their children, but with their caseworker. And on occasion, you will see very glowing and positive statements of how visits are going, and then when you get to the best interest report, there's no relationship, there's nothing going on here, we think you ought to terminate. And it may be helpful to point that out, particularly if you have the same caseworker preparing the same report. So, well, how was it that the visits were going so great 6 months ago or 9 months ago, and now they have no relationship whatsoever? So you have to be creative as a juvenile court parent's attorney and be willing to work a little and dig a little to make sure that all the information that's before the court is reliable and accurate. I'm so glad to see you, Alan. So where are we? So we're getting there. Admissible evidence, we talked about that. So if it's related to the best interest of the child, then it's going to be admissible. And so good. And here we get to the bonding assessment or attachment assessment. I did this a while ago. Those are going to go in, and all other evidence that's relevant and in the best interest of the minor can come in. And that can include information about the foster placement. Is this a foster placement that really is going to be a good foster placement? Or how often has the child been bouncing around? How long have they been in this placement? They just got there 2 months ago, but they want to adopt, and that's okay. So we can now keep in mind there doesn't have to. The case law says you don't have to have a permanent placement for the child to terminate their rights. But when you look at the best interest factors, it is a consideration. So if the placement's not been a very permanent placement, and your client's done a lot of services and has a chance of getting this kid back in 3 to 6 months, maybe. By the time they have any level of permanency in the new placement, that's an argument to be made. So again, you have to kind of think a little bit outside the box, but also be aware that these factors are here for a reason. They're there to be considered. And, it's not, probably the wrong way of putting it, but this is not the adoption factory. That, this is a serious business. We only want to terminate in cases where really, truly is going to be in the best interest of the children for that to happen. All right, so I don't know if I got any more. Okay. So anyhow, you've got my name, you have my email address. If I got anything wrong, let me know and give me some case authority or statutory authority to support that. I will be happy to change what I've been saying. I'm trying to get this right. What I've tried to do is give you information that is accurate and supported by either the statute or case law. When I haven't, I've told you that, I think. So I'm pretty much ready to wrap things up unless there are other questions.
So one from the one for attachment assessments.
Well, there's nothing in, no, sorry, hi there. There's nothing in the statute that talks about a bonding assessment or attachment assessment. It's just based on the best interest factors. It's common practice in many jurisdictions, almost all the ones that I've been in, downstate anyhow, that if the parent's attorney feels that there is an attachment or a bond, that request is typically made and typically granted. And that the only other thing I will say, and I can't put my finger on the case, but if you email me, I'll try to get it to you. And there are cases, or at least one case, that refers to the bonding assessment and the best interest hearing as getting admitted. So the courts know that they exist, the courts acknowledge their existence, and the courts allow it to be introduced into evidence. And the statutory best interest factors talk about familial ties, they talk about relationship, and so the authority is the moral authority and really getting it right, for the court getting it right in terms of the statutory factors at this point, you know. And really, to some degree, I think, even though it's not required, there's not a shall in there that you shall do that, I think that, you know, if you're a judge, you do want to make sure, you know, if you're denying that, you know, and you're just denying it just cold, it just doesn't look good in the appellate record. You know, everyone's scratching their heads and thinking, wow, you don't want to know that information? That's interesting. Now, having said that, there are going to be some cases where I probably wouldn't ask for an attachment. And nobody's going to scratch their head if it doesn't get granted. So like everything in this business, you got to, you know, this is an art as much as it is a science. So you have to know, you know, when to hold them, when to fold them, I guess. So any other questions?
Putative in our county, which I will, for anonymity purposes, call shampoo. We have two judges, and both of them will appoint counsel for a putative father. Both of them will ask for a DNA test. One insists that the putative father who has the attorney start services. The other judge doesn't care one way or the other. The judge that wants them to start services has come close, and a couple of my clients holding them in contempt for not starting services when he's given them a lawyer and has ordered them. You seem to indicate that a putative father should stay out of the hall until paternity is established one way or the other.
Well, the problem is that there seems to be sort of this idea of we don't really know what to do with these putative fathers. As you just mentioned, you have two judges in the same fictional county who don't know they don't do the same thing. And I can tell you that is universal throughout the state of Illinois. You go to another county, it's completely different. You go to some counties, they don't have anything to do with the putative father. Some counties insist that if the county I'm in, if I had a guy sign a VAP, they said, well, you can't be the father. We're going to make you the unfather. We're going to declare you a non-paternity. So there's a broad spectrum of reaction to the putative father. What I wanted to impress on everybody is that there is a solution in the Juvenile Court Act. And there is a process in the Juvenile Court Act for dealing with putative fathers. like it or not, it's in there. And it requires that the state's attorney or whoever's bringing the petition provide a notice to the putative father. And essentially you're saying, hey, are you in or are you out? And all the putative father has to do is say, I declare my paternity, and they're going to get their attorney, they're going to get an opportunity to participate in that case. That's what the statute provides. If they say, I deny paternity, they will say, thank you, you won't be hearing from us again. And that's the end of their involvement in that case. There's no reason to appoint an attorney. There's no reason to require them to do services. Frankly, putative fathers, if you really think about it, are just a name that some mother threw out. She could have thrown out John Doe or Harry Smith or whatever. They're literally strangers to this child until their legal rights are established. And we have a hard time dealing with that because it's kind of, but what I'm trying to get at is there's a process. If we follow that process and they either decline to accept paternity or simply stop showing up, then there's a step in that process to deal with it.
What if what they say is, I don't know if I'm the father or not?
Right. So there's the second question is what happens when the guy shows up? He says, I think I'm the father. I'm not sure, could be, might not be, but I don't want to commit to it without, getting a DNA test or something like that. It's really what they're coming to do. So they're lukewarm. So the question now is, well, whose responsibility is it to establish their paternity? I think the state's attorney's office, DCFS, and in particular the Attorney General's office and public aid would like paternity established. And for different reasons. Understandably, DCFS and state's attorney, they want to know who the fathers are. If they can get the father in, we're done. If we get the termination, we're done with that too. There's a lot of reasons for that. But, in a state where we are dealing with budget problems and we're having to, we're paying for a lot of things, there's nothing in the statute that requires the state of Illinois to pay for people's DNA tests, to pay to establish their paternity, to give them an attorney to be able to establish their paternity. And there's nothing in the Juvenile Court Act that requires that either. In fact, that's really contrary to what the Juvenile Court Act explicitly says. But there is that's why you do the publication, right? If you send out the notice, they either declare their paternity or they decline, reject it. If they don't do anything, then what do? You publish. Unknown fathers. You do your publication right, you're covered. And if they don't step forward, they're not in the putative father registry. By the way, I found out the state's attorney can't check the putative father registry, but the guardian can. And you cover all your tracks, then I think you're good to go, just like any other proceeding involving paternity. So.
And then this is of course different for a legal father whose name appears on birth certificate, for example. That person father.
Well, the legality of fatherhood is determined by the Illinois Parentage Act. So if the Illinois Parentage Act says that all you need is your name on the birth certificate to be considered the legal father, then the answer is, go for it, you're good. I don't think that's what it says, but I would just refer, it changes all the time, so I would ask people to look at the Illinois Parentage Act. Typically what's happened lately, if you have a fairly recent younger child, most of the medical institutions are now requiring that the person sign a voluntary acknowledgement of paternity before they will put the name on the birth certificate. But if you have an older child, that may not be the case. They may appear on the birth certificate but not have signed the VAB. And so you may have some issues there. By the way, this is National Donut Day, and I knew there was something special about today, but anyway. Thank you. Appreciate you being here.
We're going to take a brief minute and switch PowerPoints here.
Is this one correct? Or is that the one I had up?
That's the one that you had up.
That's the first one.
So we have
My bad. I thought I had it highlighted.
Okay, so thanks again to Louis for all that incredibly helpful information. We're now ready for Alan Novick, who I mentioned this morning. He comes to us from Bloomington, Illinois, like Louis, with a distinguished record of experience in child welfare and representing parents. He's also published in the field, is a longtime trainer, and has provided representation in literally hundreds of appeals, and in even more, most notably for what he'll be talking about today, administrative appeals before DCFS administrative law judges. He's been amazingly successful in his appellate practice, and we look forward to his sharing his knowledge and expertise about the administrative process that goes hand in hand with what happens in court in juvenile cases. So thank you to Alan for sharing his afternoon with us.
I want to begin by talking about my amazing success. Thank you. I tell my clients that with regard to my appeals, I win well over 12% of my appellate work, well over, because it's hard with the way the standards are up. So the red button?
Just the arrows.
The arrows. Oh. What?
Back and forth. They're appearing
Oh,
behind you and on the
Oh,
screen.
here we go. I apologize. All right. Good afternoon. I'd like to chat with you today about two broad topics pertaining to abuse and neglect cases. The first deals with areas of the law related to abuse and neglect, but not in the courtroom. It's what I tell the clients when they walk in. The big picture is what I call it. And secondly, I'd like to spend a little bit of time talking with you this afternoon about the role of visitation in furthering getting our clients their kids back. I know Louis this morning talked about many of the orders, and he covered visitation probably in a procedural sense, in a sense of how the orders come down from the judge. I'm going to talk just a little bit about substantively, in maybe more of in a social work sense, about visitation. Please feel free to raise your questions at the time, and we'll have also some time at the end of the day, I'm told, for maybe a little discussion. Okay, first the big picture. When parents walk into my office and they're carrying paperwork from DCFS or the state's attorney's office relating to DCFS issues, there's usually several things going on simultaneously. So I try to be patient. I try to listen to all the facts and the anger and the fear that is pretty obvious. And after a while, I pause and I say, folks, I want to just pause. You've given me the basic information. I want to tell you just a little bit about the big picture so that we can put this into some context. And I look at mom and dad, if that's who walks in, and I go, when these situations come up, 4 bad things can happen. Let's just talk about the 4 bad things, and we'll see how each of them apply or don't apply to the facts of our case. The first thing that can happen is that you can get indicated by DCFS. That is, an investigator will come out, will, in response to a hotline call where the reporter, often a mandated reporter, has made an allegation of abuse or neglect, and they interview that reporter. They chat with the child. They're now required to at least make a good faith attempt to talk to the AP, the alleged perpetrator in the case. And then they've got to chat with their get some background information, chat with their supervisor, and then come to a conclusion as to whether or not this person is going to be indicated for abuse or neglect. So that's the first thing. And that really means that you're in the state central register. You're in the bad guy database for 5 years if you ain't done much, and for 20 or 50 years if you've reached the big leagues. So we talk a little bit about that. The second thing that can happen, obviously, is that there can be a juvenile case filed in abuse neglect court. And the petition for adjudication of worship will allege that you neglected the child by creating an injurious environment, or abused the child by clobbering or abusing him in some way, shape, or form. And very often they've walked in with a petition for adjudication of worship, so they get that. The third thing that can happen, if you're unlucky, is that there can be a criminal case filed in. And that can be something as mundane as domestic battery or child endangerment. And if you've done it wrong, really wrong, it can be physical or sexual abuse or murder. And then I look at mom and dad and I go, and the fourth bad thing that can happen, obviously, is that you guys can get divorced, especially if you're going like this in terms of he did it, she did it. I try to explain to them that I will be very happy to help you on the indicated case. I'll be glad to go to juvenile court with you. I don't do a lot of big-time felonies, but I do some little bit of criminal work. And I make it very clear that I ain't doing your divorce for either of you. I did that about 35 years ago for a couple years and decided that very nice people can become lunatics during that process. And I often wanted the other guy's client to go away and die. And often I wanted my client to do the same. And very often I wanted them both to do it together. So I decided murder wasn't a good career move. So I stopped doing divorce. So let's talk about some of the issues. Let's give you an overview of some of the issues that occur outside of the juvenile court context in the administrative realm, and then a little bit about visitation. I begin not really so much with Santosky versus Kramer. That is the seminal case from the US Supreme Court that has been referred to already, that changed the burden of proof from very, very easy to at least a fighting chance at the adjudicatory or at the unfitness stage of the termination proceeding. The more I read the case, the more I believe the court got it wrong with regard to best interest, because all too often, once unfitness has been decided, it just seems that the rest is perfunctory. It just seems that the ball game is over. But I'm not really here to talk to you so much about Santosky as I'm here to talk to you about the guy that litigated it, and that's Professor Guggenheim from New York University. And I went to a conference, I think Lewis may have been there a few years ago, and I think Matthew was there a few years ago. And it's the first morning of the conference. It's Monday morning at 9 o'clock. We're all barely awake. And Professor Guggenheim comes out. He's our keynote speaker. And he says, you know, how many of you people are parents, attorneys? And most of us raised our hand. And he said, how do you feel about yourself? I thought that was an odd thing to say. And he said, well, I know how you feel about yourself. Most of the time you think your clients don't like you. You haven't done enough for them. You haven't gotten their kids back. And the prosecutor doesn't give you any respect, and the caseworker never returns your calls, and the GAL barely talks to you, and your life sucks, doesn't it? And that's how Professor Guggenheim started off the proceeding. And we were all sort of going, yeah. And then he looked at us and said, get over it. You're doing good work. Keep doing the good work. This is a mission. And he fired up the crowd, and it was fun. And he basically said, you're worthy. You are worthy, just like Garth, just like Wayne. You are worthy, and you're doing good work, and I encourage all of you. I feel very grateful. I'm out of divorce. People say to me, how do you do abuse and neglect? And my response is, I don't do divorce. Life's really pretty good. I enjoy helping people. I enjoy getting people their kids back. That one time out of 10 or whatever that we were able to do that. It's a good thing. Okay. So let's move on. I've got too much stuff here. Let's move on to The first area of administrative law that I want to talk about, and that's the indicated finding. And these two screens are fairly dull because they're just a listing of Part 336 of 89 ILAC, the steps that we go through in order to get through an administrative appeal. So the first concept I really want to talk about is the concept of the eligible perpetrator. If you are home and a burglar breaks into your home, and in the process of stealing your stuff, he swats your kid, that's abuse to your kid. But DCFS is not going to indicate him for it. And the reason is he's not an eligible perpetrator, and he's not an eligible perpetrator because, fortunately, he's not a person responsible for your child's welfare at the time of the alleged abuse or neglect. And you can go on to read the rest of the definition there. We litigated a case in McLean County recently. A police officer is called to a school. Now, as you know, most schools these days have resource officers. These guys are very specially trained to deal with all sorts of kids, including the really tough ones. And this day, the resource officer was at another school, and this cop is on the beat. He's just a regular cop. He doesn't have the training, and that was one of the things that we argued. And that was, you'll see, of course, he gets indicated, and he walks into the school because he gets this frantic call from the school. There are two kids in two parts of the school, and they're out of control. And he comes across the first kid, and he says, "You knock it off, or I'm going to..." And this kid does what a kid is supposed to do when he sees a cop. "I'm sorry, officer, I'm done." Okay. But he can hear the thrashing down the hall. And he goes down to the hall in this classroom, and this kid is only 8 years old. He has thrown chairs. He has ripped stuff off the bulletin board. He is swinging at the teachers. And he did what a police officer is supposed to do. The kid was wearing a winter coat. He picks him up by the scruff of the coat, puts him against the wall, and says, "I would prefer that you stop screaming." And he takes the kid down to the principal's office, which seemed like a pretty regular thing to do. But the three teachers that he saved in the classroom were offended, and they all hotlined him because he abused the child who had been abusing the teachers. And we litigated that case and lost it on the administrative appeal and eventually won it in the appellate court. I didn't. Somebody else was much brighter than I. I tried the case. And he was not an eligible perpetrator. He was a cop doing his job. And that's the first thing you have to decide with regard to the whole issue of can you be indicated in the first place. I'm going to take a little bit of a detour and talk about something I know very little about except what I've read about, and that's Dupuis. Everybody familiar with Dupuis? There's some litigation, there's some class action litigation that occurred up in the Northern District in Chicago. And Dupuis is one of the plaintiffs. And as you can see, Dupuis versus Samuels versus McDonald versus McEwen and versus, this case went on for a long time in Chicago. But it started out with three issues that were involved. First of all, the department, if they're going to indicate you, if you have, let's say you've left your kid home alone, and that's an allegation number 74, inadequate supervision, the first thing they have to do is to prove that there was credible evidence to show that you have done this. What's credible evidence? It's some evidence, but it's not a great deal of evidence. And so the first question raised by the plaintiffs was, don't you need a little more than just some credible evidence to indicate somebody? The second issue that they raised in the class action were what procedures could be used during investigations. And lastly, is the expungement process adequate? That is, were the people who were being indicated, were they being given an adequate opportunity to appeal the case? It addressed a few other issues, including the safety plan issue and the general fairness of the administrative hearing. Was there a class? There were 145,000 people who were eventually made part of this, people who had been indicated left and right, willy and nilly, for all sorts of things. And as the discovery occurred, we learned that 75% of these appeals were dismissed. But the problem was, while they were being dismissed, parents were without children, people are losing their jobs, And the federal court found some of the procedures that the department used were inadequate. So it starts in 97, and by 2003, the litigation goes to trial, and it turns out that it was taking 18 months to get these cases through the administrative process. And that's why for 18 months, sometimes parents were without their kids for really not a good reason, and people could easily lose their job in that 18-month process. We're now in 2005, and the circuit court upholds, or I should say the Seventh Circuit upholds the concept of credible evidence. It doesn't take much to indicate you. But one of the good things that occurred about Dupuy is that people are starting to get expedited appeals. If you're a child care worker in any way, shape, or form, at least the appeal process is running a little quicker at that point. There were problems with safety plans. If DCFS comes knocking at your door and there's an allegation of minor inadequate supervision, they don't generally take your kids away. But for a lot of things more serious than that, the investigator would look at you and go, okay, we believe this is serious, and we're going to ask you to sign this little piece of paper. What's that? Well, it's a little safety plan. The kids need to live with Uncle John and Aunt Mary until we can just sort this out. And at first, the department wasn't really giving people an option. It was telling them, this is what you will do. And if it was just for a couple of days, that's one thing, but safety plans were going days and weeks, and investigations were going much longer than need be. And in December of '05, the district court ordered a process where you can't have endless safety plans anymore. By '06, the Seventh Circuit tried to make the service plans more uniform, and the Supreme Court refused to hear the case. And so now we have Rule 336.85. Child care workers get the expedited appeal so that at least they can hopefully not lose their job. That's the purpose of that. And if you're indicated now, you don't get a hearing and a result on your case if you're a non-child care worker for about 90 days. But if you're a child care worker, you're getting them much quicker. In fact, they even require that the hearing date be set within 7 days of the pretrial. Now, when you have a pretrial on an administrative case, the purpose of that pretrial is pretty straightforward. The DCFS prosecutor announces what documents they want in and what witnesses they want to testify. And then the hearing is set, 25 or 50 days later. That's fine. I've been to a couple Dupuy pretrials. You don't have discovery. You don't know who the witnesses are against you. And basically the pretrial consists of, what do you want to tell us? Why is your client not guilty? Well, you tell them that and they go, it's not enough. I'm not sure that this has helped a great deal, having an expedited hearing where nothing substantive can possibly happen. The bit of good news is that within 35 days, after that 7 days after that pretrial, you're going to get an answer, which is much faster than you're going to get an answer in a regular DCFS administrative case. Okay, so we're at Rule 100, the rights and responsibilities during an administrative hearing. And obviously you can present witnesses, you can present documents. The hearing will be tape recorded. If you decide to appeal it, ultimately, if you go to administrative view, that little digital tape recording will be typed up and transcribed, and you get a hearing. The department can add allegations after the pretrial, but if they do, if you allege any kind of surprise, you get your case continued, and the department still has a fairly minimal burden of proof, and that's the preponderance or greater weight of the evidence. Rule 110. the administrative hearing and the pretrial conference. This is important because you don't always get your hearing. If there is a pending case in juvenile court, if there is a pending case in criminal court, and the allegations in either place are substantially the same as to what they've indicated you on, the department wrote a rule, and the rule takes the position that you don't get a hearing. We're going to see what happens in criminal court first. We're going to see what happens in juvenile court first. If you win, we'll give you a hearing. If you lose, we won't. So you have to structure things very carefully. If, let's say, you're in juvenile court, or I should say, let's say you've been indicated, and the allegation is number 11, cuts, welts, and bruises, and you're simultaneously charged, let's say, with battery or domestic battery, you got to resolve the criminal case first, and you can't tell your client, take supervision on the battery and run, which sometimes you might decide to do, because if you really want to have an administrative appeal, by taking supervision on the battery, the department says you don't get an appeal.
I've had a different experience with that.
Tell me.
I've had a guy take supervision on battery on the kid. No entry of a finding, and we went on to the appeal.
And you got an administrative appeal.
Well, that's not what stopped the administrative appeal, was the outcome in the juvenile court. Juvenile protection matter did.
What happened in juvenile court?
Well, we had findings there.
Okay.
But the point is that nobody batted an eye about
Supervision.
the supervision on the criminal
Okay.
side, misdemeanor criminal charge.
Okay.
Which kind of surprised me. I thought it would be the other way as well.
I would say be careful, because I've had to undo things in criminal court or juvenile court so I could get my administrative appeal. And this gets to a practical consideration. Folks walk into your office, they're in juvenile court, they're being indicated, and they say, should we also have an indicated appeal? And I say, Dad, what do you do for a living? I pick up garbage. Mom, what do you do? I'm a nurse. I'm a child care worker. Well, Mom and Dad might have a difference as to whether they need to have the appeal. I suspect the guy that picks up garbage, all due respect, might not lose his job, whereas the child care worker will lose their job. And so I just try to be practical and tell them, these are the implications. What do you want to do? The pretrial is a telephone pretrial. It's a pretty perfunctory situation. The ALJ calls you. He or she calls the prosecutor, who is generally sitting in the next office over or down the hall. And prosecutor, name your witnesses, name your exhibits. Novick, do the same. And they set a date, and then they read you that long now admonishment about, I'm required to give you the very first date. And you can take that date, but if you don't, then the days are counted against you in terms of when we have to get this decided. So you try to take the first date you can. Kids under 14 are excluded from testifying unless they're essential. The department never finds it they're essential. I recently had a case where the question was whether the child was a victim of allegation 60 risk of harm, and it was grandma versus grandpa. They were fighting over the child. The child testified at the criminal case and fortunately testified in grandma's favor, so I had the transcript typed up, and I didn't have to bring in that 9-year-old kid. I had something better, something that couldn't be cross-examined, her indication that grandma didn't do anything wrong. And so we exchange witnesses and documents. Motion practice. When I was a young lawyer, I used to file motions in DCFS land, and DCFS doesn't generally hear them or want to hear them. There's an administrative rule that says the reporter must testify. So eventually, when the reporter didn't testify every single hearing, I'd hand up a written motion saying the case must be dismissed. Of course, they never did. And then when one of those cases went on administrative review, I raised that issue, and the trial court and later the appellate court said, that's what the rule says. Too bad. We're not going to enforce it. DCFS has an odd subpoena practice. You know, you want to subpoena somebody in a criminal case, you send out the subpoena and have them served. In DCFS land, you call DCFS and say, will you please have this person subpoenaed? It takes about 6 weeks to get it done. Normally, your hearing is 6 weeks or less from the time of your pretrial. Sometimes it works, and sometimes it doesn't. Yes, Louis.
Just a question. I had, they do the subpoena out of their office. What have you done when the party subpoena does not appear, does not produce?
Good question. I had a case recently where, and it was the grandma-grandpa case. Grandma and grandpa were happily married for 29 years, and their daughter went south, and so they were raising their grandchild. And things were fine until grandpa every Tuesday would just go out to go bowling with the boys. And grandma said, go bowling with the boys. She later found out that he had an alternative lifestyle, and every Tuesday there was an orgy. And she had 2 witnesses come in and say, yeah, I was at the orgy. And of course it was all male people. And so shortly after that, grandpa divorced her. And then we found out that grandpa hadn't paid taxes since 1998. So I subpoenaed the IRS person who sent in the letter saying, we're levying on just grandpa's property. Grandma had paid taxes, fortunately. And the IRS said, we ain't showing up. And so I looked at the ALJ, and she went like this, and I had a piece of paper saying that they had levied on him, and any evidence comes in DCFS land, in administrative hearings, anything comes in, hearsay, double hearsay, squirrel hearsay, it doesn't really matter. So, but the ALJ didn't do anything. What was I going to do? I didn't want to continue it again. So it's a problem.
Well, I subpoenaed school records, whatever it was, but it was not a federal entity, so it was a state entity. They did not, there were medical records, basically, is what I was trying to get.
No response.
No response or incomplete responses, and I filed a motion to have the department enforce their subpoena.
They refused.
They didn't do anything. So I didn't know if there was a solution, because it's not our subpoena, I can't afford it. They suggested that I would go into state court and do something in state court, but have you ever had any experience?
No, I have not, and that's exactly what now that I think about it, I think that's what the ALJ said to me. Well, you have a remedy, go to state court and start a lawsuit. I'm here to indicate this person. I don't really.
But it's not our subpoena anyhow.
That's right. So would there be a standing question raised if you tried to assert it? Maybe.
Sorry.
No, that's a good question.
Throw something else in that. I don't bother with going through DCFS. I send them my own subpoenas. Not been a problem. And in fact, the ALJs and DCFS staff in Cook County have been like, you can send your own. It's okay. They don't seem to care.
Okay.
And I've just not had this problem. People respond.
Here we get into hearsay. Rule 120, all evidence helpful in determining whether the alleged perpetrator abused or neglected the child, even though not competent under the civil rules of evidence. So what you have to do, thank you, Matthew. What you have to do is to say to your client at that first interview, this is not going to be a court proceeding where people are going to be successfully objecting to hearsay and something's going to happen. We have to play their game. They're going to bring in hearsay. We're going to bring in our hearsay. Let's say the child alleged, let's say it's an inadequate supervision situation, and the question is, how long was the child alone? And of course, the child says, the children will say anything to the investigator. Come on, guys. And so the child says, I was alone for an hour. Okay, that's good enough to indicate. Well, Johnny, do you remember that you only got to watch, I was only gone for one cartoon? Oh yeah, how long's one cartoon? Well, let's watch a cartoon and let's look at the clock. It's 5 minutes. So the child has now told you that he was only alone for 5 minutes. You can testify to hearsay from the child. So if they're going to play the hearsay game, I encourage. I am not encouraging, like in misdemeanor court, the preponderance of the perjury. I am just encouraging them to rethink what was going on. Okay, so within 15 days after the administrative hearing, our ALJ writes up findings of fact and conclusions of law and makes a decision. And that decision is always the decision of the department, except for occasionally. I have a lady who is a foster parent. She is also a child care worker, and she's crazy. She has taken in a child with reactive attachment disorder. Everybody know RAD? Okay, this is the syndrome you don't wish on your enemy's kids: lying, stealing, animal torture, fire setting. This kid was a very tough kid, and she takes the kid to daycare and goes back to her agency, and she gets there at 9 o'clock, and by 10:30 she gets the first call. He's acting out. Take him home. We don't want him. She goes over there and gives him a stern talking to, and he says, "Mommy, I promise I'll be good." Okay, so the daycare decides they'll take it. They'll take him. She goes back to work. Just before noon, she gets the second call, throwing chairs, kicking, spitting, doing whatever. And the daycare has said to her, "Now, take your kid home," which means she can't go back to work. Is she pissed? Sure. She tries to get him out of there. He's fighting and kicking as she removes him from the daycare. They get out to the parking lot where he goes into total meltdown, lying on the pavement, kicking and screaming. She has been trained by her own agency eventually that at certain points in time, we need to restrain the child before he hurts himself. She does what's called a basket hold. She is behind him. She's holding him, restraining him. But if she had looked behind her, she would have seen the 6 daycare workers watching the whole event, all 6 of whom picked up the phone and called the hotline. So she is hotlined for risk of harm or whatever the heck it was at the time. And we tried the case for 2 days on one restraint. And the ALJ heard the evidence and said, "This is nuts. She didn't do anything wrong." And that was the one time the director of DCFS said, "Oh, yes, she did," and overruled his ALJ. He didn't hear the evidence. He didn't see the witnesses. So most of the time, I think it's fair to say that it's a rubber stamp after the hearing, but not for this lady who lost her job. Exchange of information. I have a form letter that I give to the client right after the telephone pretrial. And the form letter says, "We had our telephone pretrial. This is the day of the hearing. This is where it's at. This is the time. I need the list of witnesses. Anybody else? Here's who I announced at the pretrial. I need a list of witnesses. If you want anybody else in, I need a list of documents now, because if you don't show them to the other side, you don't get to introduce them." And that's exactly what the rule says, because the ALJ can bar the testimony of the witness or can prohibit the introduction of the documents into evidence. Testimony by telephone. Occasionally, witnesses are busy, especially docs. And so the docs are given the usual doc dispensation that they don't have to show up. They can do it by telephone. Recently, I have a dad who has his child is living with him. Kid is 17. The kid's a little on the depressed side. Why is he depressed? Because mom just married her 6th husband, and the husband doesn't like the kid because the husband doesn't like gay people, and the kid is gay. And if the kid wasn't depressed before, the kid said, "Mom," and the kid said, "Why don't you go?" And the mom said, "Go live with your dad." And he did get depressed. And he's not going to school, and so ultimately the dad takes him, the school suggests take him to a shrink, maybe put him on something. So he goes to the shrink, and the shrink puts him on a small dose of Prozac, fluoxetine, I believe is the generic. And the doc says, "And bring him back in 2 weeks and we'll up the dose." So the dad does something he shouldn't have done. He read the disclaimer that came with fluoxetine, and here's what it says. "This stuff works really good for old people like me. And it works pretty good for middle-aged people like some of you. And the jury is literally out as to whether we should be giving it to kids, to adolescents. Because there is some studies that say it might increase the risk of suicide." So dad reads this, and he goes back for that next appointment. And the doc says, I'm going to raise your kid. And by now he's gone online and he's got the studies and he hands them to the doc. And the doc goes, uh-huh. And the doc hotlines him for medical neglect. And normally, I've never objected when a doc wants to testify by telephone, but my guy says, this SOB needs to be seen by the judge for what he is. And so we objected, and to her credit, the ALJ granted that request, and the doc had to show up and testify live. I was surprised. Okay. You always get to file your appeal. You always get an indicated appeal, except Rule 190. And I've underlined a couple here. If the department has previously made a final administrative decision, or number 3, a court has made a judicial decision on the issue being appealed, or a judicial finding of abuse or neglect has been made. Once again, you got to be careful what you do outside that juvenile courtroom. I should say outside of the administrative realm, because it does affect what you're going to be able to get away with in terms of having an appeal. And that's a larger slide of that. So I come into a case where dad says, I want you to appeal. This is an uncle. This is an uncle and an aunt who take in two of her nephews, because mom has 6 kids and mom is into every drug imaginable and drinking too much, etc. So I get them custody 8 years before, and then 8 years later the uncle comes back and says, I got a little problem. I said, what's that? Well, the kids have been since diagnosed with reactive attachment disorder, and as the result, they're really out of control. And as the result of them being really out of control, I came home one day and the place was a mess and I lost it. I didn't lose it, but I yelled at them and they said I hit them and I didn't hit them. Okay, so the other little problem is that he had already pled guilty to domestic battery in criminal court. So I said, I'll be able to do your appeal, but I got to do 2 things before that. I got to take back your plea of guilty, which is not easy because it was the 27th day, but we did. I got to beat your criminal case, which is not easy because there were 2 counts of assault, 2 counts of battery, and 2 counts of child endangerment. I forgot to mention that Uncle had a couple of drinks at the time this happened. Couple of drinks. But we had a bench trial, and we did. And then we had to go through the administrative appeal. So sometimes it's not easy to get that appeal. And that brings us to our next topic, service appeals. These are the appeals where you are appealing a situation, usually a service plan. As you know, that the theory of juvenile court is we fix parents, we make them better, we do an integrated assessment, we determine their strengths and weaknesses, we prepare a rational service plan based on that, and if you, the service plans are usually rational. Sometimes, as we've heard, they're sort of cookie cutter. Okay, let's see. So you're going to do what everybody else does. There's going to be an evaluation for substance abuse, for domestic violence, a parenting class. You get to visit. There's mental health counseling. Sometimes everything applies and sometimes it doesn't. Here's a situation where you file an appeal because it didn't apply. A gentleman from Guatemala comes to this country, and shortly thereafter, his daughter, his 16-year-old daughter, comes as well. She now has a taste of America and freedom, and she's a teenager. Now, what about this is rife for problems, and Dad has some pretty specific rules about being home and going to school, and she's not hearing anything of it. And so she's talking to an aunt. Fortunately, there was another aunt here. And she says, I can't live with Dad. He's making me go to school and following these rules. So I'm not going to live with him. Well, how are you going to do that? I'm going to tell him he sells drugs. And the aunt looks at her and goes, he doesn't take aspirin, let alone takes drugs. And the kid goes, okay, I'll say he touched me. And that's what she said. And she just said fondling, that's all, and she wasn't very specific about it, but of course the department bought it. And this was 10 years before I met him, and he was indicated, but at the juvenile proceeding, he always denied it, and he was never charged criminally. So the only adjudicatory finding originally found is that he couldn't get her to go to school, which was true. Fast forward 10 years, she's gone somewhere. He finds a new lady. He has a bunch of kids. They split, and the lady and her new boyfriend have a domestic violence situation. So everybody comes to juvenile court, and of course, our guys had 2 kids with this lady. And what happens? Well, he was indicated 10 years ago, and he never appealed it. He doesn't speak very good English, let alone appealing it, 10 years before. So the service plan said, guess what? You have to go through 5 years of sex offender evaluation and treatment. And he said, for what? Because you were indicated 10 years before that. We did appeal the indicated finding. We found the aunt who the kid said, he does drugs. Oh, he doesn't do drugs? He touched me. And the aunt testified to that. And to their credit, they took away the requirement that he do sex offender treatment. And eventually, that's a return home case, isn't it? Okay. Okay, so as you can see, these are just a litany of who can appeal. These are just the, some people are perverse, and I like to read DCFS regs. I don't know, they're sometimes exciting. So one of the issues is your service plan. You appeal the service plan. Another reason you'd have a service appeal is you're appealing the removal of a child from a foster home. The example that's come up twice in my little career is we have a foster parent who's taken 2 siblings. And one of the siblings has reactive attachment disorder, and the other sibling doesn't. And the sibling, and I'm no expert in this area, but I can tell you this, if you have an RAD kid in your home, you really hope it's the only kid in the home, or if not, it's the youngest and the cutest kid in the home who's going to get the attention. But as you know, these are tough kids. So in any event, the foster mother, who was a special ed teacher, a fairly, I would say, together person in dealing with children, saw child A beating on child B too many times, gives notice on the RAD kid, and what does the department do? Gives her a notice of decision saying, we have to keep children together. So important. Well, and now when you look at the reg that deals with when we keep kids together, that is the policy, except when one kid is beating on the other. And so that's when you file a service appeal and you attempt to separate kids. They don't like it, but it's got to be done. Sometimes you file a service appeal when we're just fighting over money. And that's when you believe, you look at the regs, and it's getting harder and harder to specialize kids given our budgetary constraints. But sometimes you go to a child and youth investment team, and you tell them these are the reasons this kid needs to be specialized. And DCFS these days, unfortunately, always says no, we're not going to do it. And you can have a service appeal with regard to that. And here's a slide on the SAYET. The SAYET action plan is a document where we're trying to do a clinical assessment. What does this child need? What resources do we need to gather in order to help this child? Due to current budgetary constraints, foster parents hoping to specialize a child may have to decide if they can live with a problematic child, because except in the worst cases, ain't gonna happen. Another kind of service appeal is situations where we've decided to move children for other reasons. Sometimes we're moving children back home, and you don't get to appeal that. But sometimes we're just moving children where we've split the kids up for good reasons, and then we're trying to determine whether we should return them together. These are situations when clinical services gets involved. Everybody had some familiarity with clinical. I generally really enjoy working with the folks at clinical. I do believe that they have some expertise. Their caseload is not great, but they do try to listen and make tough determinations about when kids should be separated or kept together. Sometimes foster parents are appealing situations, and they'll ask for a service appeal. Had some foster parents who had 2 of the 5 kids, and within a couple of weeks of getting this, and this is, of course, it's our first go around as foster parents. As you know, the system eats foster parents on a regular basis, unfortunately. And within 2 weeks of having these kids, the worker says, "You want to sign the adoption commitment papers?" Sure. Yeah, we like these kids, so they do. And because they did sign them, they said, okay, since you're telling us they're going to be our kids, in 6 months, my nephew is going to graduate from the Marine Corps in San Diego. Can we take the kids to see them? Yeah, not a problem. They're going to be your kids. We'll put in the paperwork. That was the last thing they heard. And instead of putting in the paperwork, they didn't put in the paperwork. And as time went on, they realized that the department had just changed their mind. Although they had asked them to commit to adopt, they hadn't told these people that they were going to try to reunify all the kids. We asserted that the Foster Parent Bill of Rights says you're going to give us a service plan. You're going to tell us a little bit about why the kids are in care. You're going to give us this information. So I said to the client, let me see the copy of the service plan. Well, we asked for that, and they just kept saying they were going to get it to us, and they never did. And that's why you file a service appeal. You file one because the agency has decided, has changed their mind and just not told you, and they've blown you off. Sometimes service appeals are filed by relative caregivers. And there's 2 kinds of relative caregivers. If you're licensed and you've had the kid in your home for 60 days, you can file a service appeal. If you're unlicensed, you have to wait 90 days before you can file any kind of a service appeal. Once again, certain things cannot be appealed. And Rule 33780 talks in terms of, once again, the final administrative issue has, final administrative decision has been decided. When the issue involves a service that the child does not currently need, but may potentially be needed in the future, well, that's often a difference of opinion between foster parents who live with this child on a daily basis and an agency concerned with trying to pay its bills. And they say, yeah, that child will need that in a couple years, but we don't have the money now. That's not what they say. They say, we just don't think it's appropriate at this time. With regard to any of these, whether it's an indicated appeal or it's a service appeal, many of these are subject to judicial review. That is, you can file essentially a lawsuit against the state of Illinois when you have no other recourse. And when you do that, if you've never done it, you have to be ready for the fact that you're now going to get an army of attorney general lawyers who are on the other side. What do? First thing they do is they stall and delay, and you have to file a motion for them to file an answer. And all the answer is typing up the record and handing you a transcript. That's the answer. The last time I did that, there were 3 motions I had to file before they filed the answer. We're busy. They can't find it. And then all you really do is find an agreed upon briefing schedule and try to convince a circuit judge in your county or in the county you file it in that the department has abused its discretion. In juvenile court, when kids are taken into protective custody, they're not always placed with people that the biological parents hope they would be placed with. If you don't do something quick, you're generally stuck because the department is reluctant to move children for any reason, let alone a good reason. And so oftentimes, if the investigator is doing his or her job, they will make some inquiries as to where the children could be placed. And as is common in the class war that we all fight on a daily basis, the people, the relatives of the people whose kids have been taken have DCFS issues, have criminal issues, and you have to, but they want to find somebody they trust. The magic word is the godparent. I always thought that was something that happened at birth, but very often there's an investigator with a form. Who do you want to be your godparent? And then there's a quick huddle and they put somebody's name down. And then all of a sudden they are put to the top of the list in terms of people who can be eligible for placement, provided they make the same background checks as everybody else who just failed. Foster parents. It says here that they should be treated with dignity and part of the professional team. That they're supposed to get pre-service training. They're supposed to get adequate support services, timely financial reimbursement. Sometimes that happens. It's nice when it happens. That's the case I just gave to you, the foster parents who within 2 weeks are told that they should sign up to commit to adopt, and then shortly thereafter they're told that they're persona non grata. They were not given any of the things that are listed in the foster parent rights. You know, if you're really trying to help this child, it makes sense that you're given a copy of the child service plan. It makes sense that you have an understanding of the reason the child came into custody in the first place. Whether the child has been physically abused, sexually abused. It was frightening to hear that these foster parents had been getting none of that. And that brings us to a discussion of foster parents. There's a lot of ways to refer to them, and I have a simple way. There's two kinds of foster parents. There are the saints, the people who have taken in kids year after year, have fostered them, some who seek to have the handicapped kids taken into their care. And then there's nothing wrong with the other category. These are the people looking to adopt. The people who, for whatever reason, can't have kids. There's nothing wrong with that. But as a parent's lawyer, I often try to make that quick assessment. Why are these folks here? Some are more willing to work with the biological parents. The best foster parents you could ever have are the foster parents who say, caseworker, would you mind if I allowed the parents over for Sunday night dinner so we could talk about the issues? These are the real saints in life who are willing to serve as role models, as teaching models for these parents. Let's face it, our parents are imperfect creatures. We all know that. Some of them, most of them, are the victims of inadequate parenting themselves. And so they do need good role models. And the saint foster parents are, you find those, you are so lucky. And of course, the bio parents don't understand that at the time, and hopefully they pick it up later. Clinical, DCFS clinical. These folks have the education and the experience to sort through tons and tons of paperwork of social service documents to review a disputed decision as to whether to remove a child from a home. I get a call from a lady out of state. I want to adopt my niece. My niece is in foster care, and I knew she was in foster care before, but I thought, and it's my great niece, but I thought that the parents were going to get their act together, and I talked to the parents recently, and they said something about this TPR thing. And she said, "What's TPR?" And so I told her, and she said, "Maybe I ought to be involved about this." And so she contacts DCFS, and the child at this point had been placed with the foster family for a year. And when she called me and she told me that, I said, "Ma'am, I think you're wasting your time. This child's been with this one family for a year. Unless there's something radically wrong going on, the statute gives them the first dibs. So there's not much I can do for you. I want to try." Okay. So the department gave her a visit. She flies in from out of state, and she gets a visit. And they eventually decided to give her a visit every month. And I went, wow, that's cool. I don't know why, but it's good. So I filed a petition to intervene and a supplemental petition alleging we'd like the court to terminate the guardianship and allow our out-of-state people. And in the meantime, they go through the ICPC process. In fact, they lived in 2 states in the Northeast and in Florida, and they go through the ICPC process twice. I thought it was a lot of work for nothing, but they did. And I'm at a pretrial before we're going to have a hearing on my motion, and the caseworker says to the judge, "We're going to do a clinical on this family." Since when does the department do a clinical on a family? By now the kid had been there 15 months if there's not something going on in the foster home. It turns out they do the clinical, and there was something going on in the foster home. There were 6 kids in the home, and the 2 biological kids had been ordered by the parents to move across the street to grandma's so that the capacity, the foster capacity, would be adequate. That in and of itself is, I don't know, I didn't think that would make a difference until I read the clinical. And the clinical said after 15 months, this kid hadn't bonded with the foster parents. Holy cow, what is going on there? Now the case is set for a contested trial, and clinical is firm in that this kid should move with the relatives. Normally clinicals take 2-3 days to do. 4-month clinical. Anybody ever hear of a 4-month clinical? I've never heard of a clinical that lasted a week in my life. Okay, so how do we get to clinical? We get there when before we get to a service appeal. And you can see in the reg, and I apologize, this must be, 337, somewhere around there, I apologize, I don't have the number there. But you can see the process that clinical goes through in order to do the review. And you can also see the following placement changes shall not be subject to clinical review. A change in the substitute care when child's been placed in a licensed foster home for fewer than 60 days, we're not going to do a clinical, or unlicensed for fewer than 90. If we're consolidating siblings, you don't get a clinical. If the kid's already in a specialized home or in a group home or in a transitional home, we're not going to do one. And you don't get a clinical if there's an allegation of something that puts the child at imminent risk of harm. And you can see where you send your request. Oh, maybe if I turn the page. You can see where you send your request to ask for a clinical placement. Okay. that's all I had this afternoon on the issue of administrative issues. Anybody have any questions? Yes, sir.
Pretty clearly, people don't get a lawyer for the indicated appeal. Is that?
Well,
Appointed counsel.
Yes, that's a great point. No, the question was, do you get a lawyer to challenge the indicated finding? And the answer, a court-appointed lawyer. And the answer is no, unless you get me in juvenile court, and sometimes I just do it anyway. Because otherwise, the rest of the case is not going to proceed properly. Mostly in a service appeal. I've not done many indicated appeals just because I'm a nice guy, but occasionally I'll do a service appeal. Don't spread that
There's
around.
no hope of getting appointed counsel. I'm with the public defender's office. I have only one indicated case that I helped the client, but I kept saying, you know, I'm really not supposed to
Good for you, though.
do that.
Did it
but,
work?
She did it pro se and was pretty good. It's not done yet. Got through the exchange of witnesses.
I have a feeling that you're giving her some pointers as to how to conduct herself, though.
She wouldn't listen to me if I paid her. Not in a mean way, but she's fairly self-confident.
Good. Anybody else?
Is there a, if you draw an ALJ you don't particularly care for, is there a mechanism for equivalent of an SOJ?
I don't believe there is in the rules.
I ask because I've been looking.
Are there-
Able to find them.
I deal with about 5 or 6 ALJs here in the central region. And I don't know if I'm easy. I don't think I am, but I like them all. You know, most of these folks have enough common sense to be able to separate, on the one hand, serious physical and sexual abuse, and on the other hand, not so serious situations. And that's all I'm asking for, is to be able to look at the big picture through your life experiences, and I don't have a problem with them. I've been lucky, maybe. Okay. Visitation. I know Lewis touched on this morning, how important visitation is, and I believe he talked about some of the mechanisms in 2-10 for ensuring that the client gets a decent break in terms of visitation. I'd like to go back in my little Wayback Machine. I was on vacation in 1997, and I come back, and I was a PD at the time. And I come back, and it wasn't unusual for me to have a new file on my desk. But of course, new files, there's a shelter care report, there's a petition, and a shelter care order, and it's not much. And I come back and I have a banker's box on my desk. That's odd. And so I'm reading through my banker's box, and I find out that this case has been going on for a year and a half. This mom sexually abused her child. Unusual. Let's just say she touched her below the belt on one occasion. The child was old enough to articulate it happened on one occasion. Mom pled guilty, said it happened on one occasion. And so she pled guilty to a felony, got 6 months in the county, got probation. And that's when I met her. This was back during the days where if there was a felony case and a juvenile case, they made the felony attorney take care of the juvenile case, even though they're never in juvenile court. And when the case got set for termination, he panicked, and I got the case. Okay. So I read the file, and I get this lady in to see me, and unfortunately, it was a self-fulfilling prophecy. She had been abused as a child. She had low self-esteem. It was a sad situation. So we went over, it was set for termination, set for fitness in a few weeks, or actually in a couple of months. And I said to her, we go over each aspect of her service plan. And she said, yeah, I did A, did B, yeah, I'm just about done with C, I've done everything. And I went, oh my God, that's unusual. Why are they terminating on this lady? So I said to her, and how's visitation going? And she looks at me and goes, I didn't know I was allowed to visit. I haven't had a visit for 18 months. And I said, why not? And I looked at the file, and indeed in the criminal case for the first couple of months, there was indeed an order saying thou shalt not have contact with your kid. Criminal case was long over. The time had long passed for that. And it turns out the caseworker just made the decision that you touched your kid, I'm not giving you a visit. Simple as that. For some reason, I didn't think this was fair, and I found 89 ILAC 301-210, which is the regulation that deals with visitation. And I went, oh my God, this doesn't seem like it's something that and it was a DCFS worker at that. It wasn't an agency work, a private agency worker. So we're at a pretrial on the petition to terminate, and I look at my judge and I go, and I did my best Columbo. Judge, you know, there's this rule that talks about visitation. I don't know what it is. I don't know what it says, but I think she's supposed to have gotten it, and she never did. And I would like you to appoint me an expert, because somehow I think this violates all sorts of social work principles. And to her credit, the judge said, okay. And I get an expert. I get a lady who'd worked at the private agencies, who'd worked at DCFS, who was very familiar with the system. And she comes to my office and we go over the facts of the case, and she is pissed. Because she said that my instincts, 20 years ago were correct, and this lady had been done wrong. And she said, and I'm going to find you proof of that. And you can see in the next few slides the examples of social work articles from the Journal of Social Work or the Journal of Law and Social Work or whatever it was. And article after article dealt with how this lady, I mean, she had done wrong, but they had not done right by her. So, of course, I'm a young lawyer at the time, or at least younger, and I attach all these articles as appendices to my brief. I'm going to argue this at the 4th District. I'm ready. How many 4th District lawyers do we have here? Okay. That's when I first met Judge Steigman. And so I'm ready to argue my little heart out. And I said about 15 words. And here's what Justice Steigman said. Counsel, we don't care about your sociology. We don't care about your articles. Let's get back to the facts of the case. Okay, well, don't care. I have raised these issues in dozens of briefs since then. They have been ignored dozens of times. Don't care. I'm going to keep doing it. First article. Child welfare. Sounds like some communist pinko publication. The beneficial effects of children's contacts with their biological parents while the children are out of the home. Talks about visitation. And there's detrimental effects if you don't visit at all. Didn't have any effect on the 4th District. Children in foster care who were visiting more frequently were found to exhibit fewer externalizing and internalizing behavior problems than those who were visited less frequently or not at all. It's important for their sense of self, their sense of identity. Wait a second, isn't there a best interest factor that talks about sense of identity? Yeah, there is. It's important to convey the message to the children that it's okay for them to have positive feelings for both biological parents and foster parents. You want to make points? You want a win-win situation? You say to your biological parent, I want you to empower your child to be in foster care. And I want you to tell that to the caseworker, your service providers, and every other person you see. And I want you to tell it to your kid. I want you to empower your kid. Why? Because it's good for the kid, and it really sucks up to the caseworker. The caseworker goes, whoa, you're doing something good for your kid. It's a win-win. Child welfare. Research in the US and the UK suggests that return home is related to 4 variables, and then later it goes on to say, and one of them is the extent of parental contact with the agency. And then in the next paragraph it says, the only consistent factor that the experts agree upon is the importance of parental contact. It increases the likelihood of the kid going home. Parents who maintain no contact were less likely to get their kids returned. Increased frequency increased the likelihood of reunification. Parents are encouraged to fulfill responsibilities. You got to be careful with this one. This one talks about give the kids some pocket money. Well, the little kids, you can't give the little kids pocket money. And if you give the big kids pocket money, what's the worker going to say? You're bribing your kid. So I'm not sure about that one. But I would certainly have the parent, once again, if you get lucky and you get a foster parent who's willing to look you in the eye, make nice to that foster parent. Maybe you'll get an extra visit. Maybe the foster parent will teach you something. Maybe the foster parent will say something nice to the worker. Child and Adolescent Social Work Journal. Radical publication. If the children are to return home, their emotional connection to their biological parents must be promoted. One important way to do this is the individual visitation during the stay in foster care. Frequency is correlated with child emotional well-being. Go back to 210. Section 210 of the Juvenile Court Act, the temporary custody provision, 3rd paragraph in sub 2. To what extent should we be having visitation hearings in every single case and talking to the judge about these articles and how we need to facilitate visitation? Child development principles shall be considered by the court in its analysis of how frequent visitation should be, how long it should last, where it should take place, and who should be present. What do these articles say? Do you need an expert? Be nice to have an expert. How many PDs can find an expert? Got some articles. Children tend to have greater contact with their parents when their foster family has positive relations with the biological parents. In the situation where I had the aunt from out of state and the foster parents here in Illinois, the department has finally said, okay, during the auntie's visit, auntie is going to the baseball game where the kid is at, and it's going to sit next to the foster parents. And then the child's going to leave with auntie. It looks like a family. What a novel concept. And then when she brings the kid back, the kid has a dance recital 2 days later. And the foster parents are going to show up for that. And they're going to go back home with the kid. It looks like everybody's on the same page. Is that good for the kid? I'm thinking. Another article from Child Welfare. Findings in this article concluded parental visiting is linked to discharge from foster care. Agency visitation policies that hinder early discharge from foster placement. Examples of bad policies: an hour visit, only 2 visits a month. Kids can't come home on the weekend. many times do we ever get kids allowed to come home on the weekend? That never happened. I don't know where that came from. And one other issue is be aware of certain parents who don't have the wherewithal to be able to afford the transportation costs. It'd be nice if there was a few bucks for that. I apologize. I was supposed to be speaking for another week or two, but that's all I got today, folks. Do you have any questions? Yes, ma'am.
I had a question about your scenario with the visitation.
Yes.
How did that go on for 18 months without anyone ever?
How did it go on? Her lawyer was a very nice guy who practiced criminal law, felony law, and had never been in juvenile court till that case, and had never thought to ask. He's a good guy. He's a Cardinal fan.
That was more the problem.
Yes.
He's a good guy.
As I say to all my Cardinal friends, don't you get tired of winning all the time? Doesn't it get old? Yes, ma'am.
What about where the permanency goal is return home and foster parent is not?
Okay.
What options do we have?
Good question. You have to file a motion and and bring it to the judge's attention that, Judge, if the parent has a service plan and they don't do their service plan, what happens? They get terminated. You need to find the page of the service plan, and there should be a service plan page that says the foster parent is committed to the goals set by the court. And if it's not, appeal the service plan. If you believe that the foster parent is not one of the saints, but is one of the other folks who legitimately wants to just adopt this kid, then what you have to do is try to appeal that. So long as the goal is return home. Once it gets set to TPR, it's too late. So you got to be proactive in that regard.
What if there's a petition to terminate, but the goal?
The limbo stage. Yeah. How quick can you get to court? And at that point, is anybody going to listen anyway? We have prosecutors in our county who will file the petition to terminate before the goal is changed, before there's legal screening, just because they've had enough. Well, I understand that. And that's the same prosecutor who I walk in and she goes, "What are you doing in my courtroom?" Honey, it's not your courtroom. It's our courtroom, is my response.
And the motion to file with the judge, the only thing I could think was a rule to show cause against DCFS. Forcing the foster or keeping, they have custody and guardianship, so.
How much time you got? If you've got time, I'd appeal the service plan, and here's the reason why. I don't want the judge ruling on that, because judges are very supportive of foster parents, and I understand that. The department eats foster parents on a daily basis, and they're not as supportive. So I would start there, and then even if you lose it there, then you got another shot with the judge. Lewis.
I kind of did discover some language in the Juvenile Court Act that might be helpful. I'm not sure what to do with it, but it suggests that a petition to terminate cannot be filed by the state's attorney until there is no longer a return home. So I don't think that's been fully explored.
Do you know where that's at?
I'll find it for you. It's in the later sections. I'll know it when I see it, but it's a little cryptic, but there is language to that effect. So I've never really used it because 90% of the time
It's too
not a
late.
return home goal anyhow. But there may be some junk in it. And I'll just leave it. And I'll try to find it and share it with everybody.
Matthew.
I know you came back from Chicago and we kind of discussed how to, I don't know if the right word is attack, the visitation orders that agencies file in regards to you get your 1 hour, 1 week, and how, according to statute, that's probably not appropriate. I don't know if you wanted to talk a little bit about anything you've kind of seen or thought of ways to go about attacking that with the court, because I don't think we've had any luck since, but I'm not sure how much we've really pushed that.
I took the position that at the time of dispo, I have to sit down with the client before dispo. I have to sit down with the client and I have to determine who's the foster parent, what kind of visitation are you getting, do we have saints or do we have adoptees as foster parent? And then I did prepare a motion with regard to visitation, because when you look at the form order in the county that we practice in, the dispo order said visitation shall be at the discretion of the department. And I hate that because it makes no reference to 301-210, it makes no reference to 2-10, and it makes no reference to what's in the best interest of the child. And then you look at every permanency order after that and it just says, see the dispo order when it comes to visits. So I thought the best time to start was early on, and it was pre-dispo, and I prepared it. Did I send you that form motion? But you don't have to file it in every case. Right around that time, there was a situation where the foster parent was the grandparent and the grandparent was on our side. And I tried to file that judiciously when I think I really need to. I don't want to, for lack of a better term, piss on the foster parent's leg unless I have to. Yes, sir.
I don't know, I've practiced down in the 5th district, and what I feel like there is 1, maybe 2 hours a week visitation, if lucky. One case where there was a baby taken from the hospital, I was arguing to the judge, there has to be some bonding with this.
Yes, good for you.
And she just gave them 4 hours a week instead. And then what the provider did, because they didn't have enough people down there to work, just let them meet with the baby 2 hours at a time, twice a week at a facility that was just a room. That's all they ever got.
Does your folks have a pastor that they trust? Do they have a counselor or somebody with any street cred? Not street cred, judge cred.
I'd say no.
That's a problem, you know, because in each case, you have to look at how can I ensure my caseworker that additional visitation is necessary and will be safe for the child. And that's why any trained person with any bit of credentials is a possible visitation supervisor.
Okay, because yeah, what I'm seeing is an excuse by them all the time. We don't have enough staff, and I'm seeing a lot of bad results as part of that. And some of the stuff you're putting up here really hits home because in the end, they just don't have that bond with parents anymore.
We don't have enough staff, but the statute says that the ability of the department to have the horses to do it is not the real consideration. It's a never-ending battle. Yes, sir.
You cited a couple of the studies here, but there are a lot of studies out there now talking about the necessity and how vital visitation is, how it's the central thing. I mean, it's the #1 thing. And obviously the department is tasked with reunifying families whenever possible. Lengthy arguments. You know, you're not providing visitation, you're not fulfilling your mandate. No reasonable efforts at every hearing that comes up, not file a motion for visitation and lay it out.
And you have
and bring in an expert, bring in the studies. You lose, and then they subsequently terminate, saying there's no bond. It's part of the issue. Eventually the appellate court's going to get to it if they can.
You do have to pick your battles, Melissa.
The question is, can you appeal these through the service appeals as well and say the decision?
Yes, absolutely.
Have you had success doing that using your studies with,
I haven't done it very much. I need to do it more. That's a good
You
point.
have better luck internally than you do with the judge, absolutely.
I agree.
Absolutely.
I agree.
The statute requires the judge to review the visitation plan. In
Yes.
fact, the statute requires that there be a visitation plan, number one. Two, and provides for the court to review it. So what is the role of the court? And what would you do? Would you set it for a review? How would you?
I think that you could do it both ways. You could do it the service appeal way, which was suggested, which makes a lot of sense to me, and you could do it through the judge. And then strategically, I think you have to make the call, which is first, which makes more sense. Appreciate it.
You're good. So I don't know if there were folks that wanted to, we had envisioned having a panel on hot topics or other issues that folks wanted to talk about that weren't addressed. I don't know if there are other issues that didn't come up that folks had wanted to chat about, and while we had our speakers here, if there's any other questions that folks have. Should we just put it out there? And did you have some, Louis, it seems like has some additional stuff you might want to share too?
I just wanted, on the issue of whether or not you have a return home goal, I would just, it's the review part of this, of the Juvenile Court Act 2-28. I had it, now I lost. So if you look, these are numbered in such a crazy way that you can't really. It's 228. I think it's 2, and then good luck from there. It looks like 4. 228 parents, foreclosed parent. And it says the minor or any person interested in the minor may apply to the court for a change of custody of the minor and the appointment of new custodian or guardian of the person, or for restoration of the minor to the custody of the parents or former guardian or custodian. And then they have a separate section, and I'll just read that. It says, when return home is not selected as a permanency goal, and then I'm going to skip to B, the state's attorney may file a motion to terminate parental rights of any parent who has failed to make reasonable efforts to correct the conditions which led to the removal or reasonable progress, yada, yada, yada. So it seems from this review section that when return home is not selected as a permanency goal, then it gives permission to the state's attorney to file a motion to terminate parental rights on reasonable efforts or reasonable progress grounds, and then it goes on to say basically any other grounds. So I'm just pointing that out, that it's in the statute 228. It's deep into that section, almost a few paragraphs from the end, and I'm not sure what it means or why it's in there. It seems superfluous, but for the fact that it's suggesting that maybe you ought to wait. So I just thought I wanted to share that section.
While you're up there, you brought up the idea of defending against an unfitness petition by using latches, and our state's attorney has in her courtroom, as Alan pointed out, she's been using paragraph or
Interest
BG, no, failure to protect the child from conditions within his environment injurious to the child's welfare. Basically, they file a petition, and they allege that the reason that the child came in care is enough to find unfitness for the child for termination, and they file that many months after the case has been going. And I was wondering if that might be something that could be used against that allegation, because they're pretty much throwing things against the wall to see what will stick. But I mean, the way our court has found it is that if the child was brought into care, then that's what that allegation means. And so we've really struggled with what to do with that allegation, because we think either we have to fight every adjudication, or else we're setting ourselves up to lose at unfitness when they bring that up. And so I didn't know if that was a defense against that, if they delayed bringing that allegation until months and months later, had they lost the ability to use that allegation.
I guess it's okay for me to say I don't know sometimes. Are you saying that they're asserting that as a independent grounds under the Adoption Act? Is it?
Yes.
Okay, okay. Failure to protect a child from conditions within his environment injurious to his child's welfare. Okay, so well, I guess initially it is a ground. It is in the Adoption Act, and depending on whether we agree or disagree that if there's a return home call that's been ruled out, the state and the Juvenile Court Act clearly states that the state's attorney can file under any of the grounds of the Adoption Act. I don't believe that I could be wrong, but I don't remember whether there's a specific failure to protect as an independent basis for neglect, in the sense that, usually it's an environment injurious or abuse or something like that. So I think probably there's going to be some difficulty with the laches argument, although if it was something that was raised early, I would argue I don't have any case law to support this or statutory basis, but it seems to me we have a fundamental problem with the Juvenile Court Act and with the Adoption Act, in that they kind of are. The idea between the Juvenile Court Act is to try to attempt to get reunification, and we admonish the parents. We specifically tell them that if you cooperate with services, that admonishment that's given, your rights will. If you don't cooperate with services, or your rights will be terminated. And I think the average person sitting in the audience, our average persons, our clients, who hear that are saying, okay, cool. If I do my services, then my rights will not be terminated, or at least do them successfully, right? So there is a disconnect between that kind of language without the proper caveats, saying, when did this failure to protect happen? I think so. Now we're kind of left to the judicial interpretation. What does it mean? Okay, I think you could raise the laches argument, but I think it's not going to be an effective argument if the parent hasn't done the services and hasn't done what they need to do, which is really going to be a really good argument at best interest, isn't it? Because as a general proposition in this scenario, if they've done what they need to do, by the time you get the best interest, they're not going to terminate. So that's why you probably aren't going to see this case on appeal very often. That issue is not going to get up on appeal very often, because they're not going to be terminated on. So there's no good answer to this stuff, and I think those of us who are parents' attorneys, and I try to be diplomatic about it, but this is the worst written statute that I could find. It is. And the problem with this statute, and I don't want to pick on the state's attorney, but the problem is that they want something in there, it gets in there, and nobody thinks about how it works in a complete, comprehensive way. And so you have all these little tidbits of statutes that, well, this would be great, this protects children, we got to put this, and by the time we're done, we have this problem, right? I don't think any of us would disagree that if a parent has failed to protect a child, they should be subject to the possibility of terminating their rights, but there's more to the story to that, and it's not in the statute. So, yeah, I think you can try to raise latches, but as a general proposition, it might work out better at the best interest hearing.
Can I ask you a follow-up question? Are they filing, saying that, well, like, for example, you stepped to the whatever at the adjudication, and now we're asking the judge to take judicial notice of that step, and that's the basis for our ground G?
Basically.
Remember, at termination, to prove a ground for
It's a
termination,
different-
has to be clear and
Right,
convincing. So
right.
stipulation at preponderance shouldn't
No, it's, I
carry
mean,
any
it's,
water at all.
they're not using the stipulation or the admission itself, they're retrying
Okay.
the same facts. Just we feel that if they're going to use that and use that on a regular basis, we have to try everything at the adjudication stage, regardless of whether we think we are going to win or need to, because we have to try and win there if they're going to try and use that in the future.
Not sure, because again, because the adjudication, it's just preponderance. So, I mean, even if you lose on that count, aren't they gonna have to relitigate at termination? Unless they asked for and got a finding of clear and convincing early on.
I guess you have to believe that those differences in burden are actually adhered to.
Well, they have to be on the record. If they're not making the record, then you've got something there.
You know, the other thing to keep in mind, and I'm sorry, I'm going to digress a little bit, and I apologize in advance, but just because there's a statute doesn't mean it's in any respect constitutional. And I know we don't typically win these constitutional arguments, but you know, reading this, it's hard to imagine how that this is narrowly tailored in any respect. Failure to protect a child from something that's injurious in the environment. Wow, that really could be asbestos that they didn't know about. It could be literally anything, and it's not so much what they end up prosecuting on; it's what they could prosecute on in terms of this sort of thing. And it seems like an awfully low threshold. Now, I think we all understand, having practices in this area, there are certain failure to protects that probably would pass muster and probably surpass any threshold that we could imagine. But when this is the problem, when you see this kind of language gets popped into the statute, it's like, wouldn't it be neat if we could do this? Then you end up with constitutional problems. And and I'll be very blunt, whether our appellate courts are willing to acknowledge that at this point or not, it's sort of academic, because as a parent's attorney, and I'm kind of like Al, I just keep plugging away at this thing and become more of a missionary than I am a lawyer. But at some point, we know Illinois does not have a good record at the U.S. Supreme Court on family law cases. And I'll throw Stanley versus Illinois as a good example of that. But we have other problems. We never do very well at the U.S. Supreme Court. And until we begin to take this seriously as a state and say, look, you know, we can all be on the same page and protect children and make sure that things are taken care of. But we can't be writing these kind of broad, sweeping kind of legislation. It's just really, right now, it's okay because nothing's getting to the U.S. Supreme Court. But the day will come when something will get to the U.S. Supreme Court, and we're going to have egg on our face, and it's going to be very embarrassing to the state of Illinois. And I, as an attorney who's licensed in this state, I don't want Illinois to be embarrassed. I want us to fix our own problems now at this point. And you know, I would really say, I'd like to turn the table. If you were representing a parent and you had to face this kind of broad statutory legislation, would you feel comfortable with it? And I think if your person's honest, they say, no, this is a little over the top. But I don't know what they mean by failure to protect. I don't know what they mean by environment and juris. We still don't know what that means, right? That could be anything. So I think there may be some constitutional arguments. But yeah, laches, that's a tough argument to make under these circumstances. And then the question is interpretation. Do they mean failure to protect then or more recently? you know, because there's no timeline on this. It's just kind of, like you said, it could be at any point in time. Sorry, there I go.
There's a webcast question that is, 50B, which is interest, concern, as to the child's welfare. They're asking, what case law or guidance are you aware of that limits the time frame to consider the parent's conduct for that, for interest, concern?
There's a 2-day time frame on that. No, I'm just being facetious. You know, that's case specific, right? You know, obviously, they have to show that there's been a failure to maintain a reasonable degree of interest, concern, responsibility. I would imagine, and there's no cases on this, but if you look at the cases, it's generally a more lengthier period of time than a shorter period of time. So the shorter the period of time, the less likely you're going to be successful. The longer the period of disinterest, the more likely you're going to be found unfit. And where that point of demarcation will be, we don't know yet. I'm sure we'll soon find out because there's constant probing as to where that might be. And that's fine, because it's good that we all know where it is. But right now, the statute hasn't given us some clarification on that. I'm not the only one on this panel. I just wanted to see. Can I?
Any other questions?
I have to admit I haven't Googled this and researched it, but are there any blogs or listservs or, you know, attorneys practicing in this area with, you know, references? Specifically, I'm looking for expert witness referrals. Is there any clearinghouse group like that where on questions or ask for referrals?
Do you know the name of it?
I'm looking for it right now.
Okay. In Illinois, of course, the Illinois Parents Attorney Network would be a good thing for people to be part of, and we do share information from time to time. So, and that's kind of run a little bit out of the Family Defense Center up in Cook County in Chicago.
I'm sorry, the what center?
The Family Defense Center. So they can put you, you know, get information and get you lined up, at least be part of that. And we do these presentations. So if you run into somebody at one of these presentations, then you can contact them and get a hold of them. So we know what each other is doing a lot, and we know what experts, you know, we share some experts in that regard. Another source of information, particularly in the medical arena, would be the Innocence Projects. In particular, Wisconsin Innocence Project would be helpful in certain abusive head trauma kind of cases and fracture cases. They know of some experts. And sometimes you just ask people who do this kind of work. You know, I had to, if it's a female-related topic, shall we say, particularly involving pregnancy, the National Association of there's a NACWW. It's for females. You know, they deal with the issue of female rights, reproductive rights. They get involved in these cases too, and they actually. And again, you can email me your address, and I can get you that information too. So it just depends on what kind of expert you're looking for. The bigger problem is paying for them.
Right. Do you find the section on child law with the ISBA at all helpful?
Section. I was a member a long time ago, and I cannot give you information one way or the other because I haven't been involved with that section. I'm a ISBA member, but that's so I can for other reasons. So, but I will say that part of the reason I've been preparing materials like I have, and I think you have the navigating, is that I was very dissatisfied with what was out there in terms of, you know, materials that I could look to and get an idea of what was going on. And so that's what I've been working on to try to fill that gap. And So I looked at as many materials as I could back when I started. So,
I have another follow-up question on
Yeah.
that. You know if the judicial training materials are available? I know that the judges have training in this area.
If there are any.
the as a member of our county's court improvement committee, I was able to indirectly get some materials, not very much. I don't have access to all of it, but as many of you know, they do have conferences. I think every couple of years in Reno, Nevada is where the judicial conference takes place for juvenile law. The problem there is that the public defender doesn't really get to talk at these conferences. We rarely get invited to anything. We rarely get asked by our legislatures, what do you think about this legislation? And so what happens is what you would expect to happen is you get a very distorted picture of what really is supposed to happen or should happen or whatever. So what we would like to do is get invited to some of these judicial conferences, some of us public defenders, so that we can give our side of the story and see if we can get things working a little better. Sorry.
No, I was just
Get out
going
of
to
here.
add, so that I'm on the webcast for
Yeah.
folks, that the ABA National Parents Attorney there's a blog for the ABA, and it's a parents attorneys network within the child law unit. So that blog that's just supposed to be for parents attorneys is another, I'm not a blog, a listserv, sorry, is a place that people will sometimes ask about experts, but that's nationally. So folks all across the country will write into that and will sometimes offer up materials. And they have a conference in July in DC that happens every 2 years. And it's about to happen July 21st, 22nd, 23rd, somewhere around there. So it'll be this July and then 2 years from now. So every 2 years. I have gone in the past, yeah. Yeah, it's excellent. I mean, it's attorneys all over the country. That's what Lewis is going to be presenting at, and other folks that are from the Family Defense Center in Chicago will also be presenting this year at the national conference.
Do we have information about how to get on that listserv? I know I'm on it, but I don't
The question is
remember how.
information on how to get on it. I assume you could go to the ABA Parents Attorneys Project on their website if you just Googled that, and it would tell you how to sign up for that listserv. If someone has problems finding it, they can email any of us, I think, and you'll be able to get information about how to get on there.
It's actually one of the things that is really obvious to me is that most of the clients that we get already have enough problems, whether it be the learning disabilities or behavioral disabilities, or they were in DCFS as children and raised well, you know, that kind of thing. But there's nothing, when it comes down to these service plans, there's nothing that seems to tell the DCFS or the agency that they've contracted with that they have to address, I will call it a disability, the person, herself or himself. So it's sort of a, like you use the term scattershot, you know, show up here, show up there. Yeah, oh, by the way, you don't need to work, you can't go to school here. It's just the most preposterous thing, and I spend my time one thing at a time, and I'll talk to you tomorrow about it, because that's about as much attention span as I have. Is that something that in the service plan or the service appeal would be a valid point?
Alan, come up. Why don't you come up and answer so you're on the. So the question was about the parents that are involved in these cases. They often are at a disability themselves because they were raised in foster care or they had all kinds of underlying trauma issues, and those aren't being addressed. And could that be addressed in the service plan or an appeal of a service plan?
I had an article in the ISBA. I'm trying to remember if it was the child law section about 10 years ago that I wrote with I think it was a U of I professor, and it dealt with the ADA law and termination of parental rights. And there was just a few cases that dealt with that. I think it's something that if you, it's worth raising. I had one appeal where I had some parents that were relatively low functioning, and and they kept giving them the same services and they kept failing. And the suggestion on appeal was the old definition of insanity, you know. And so I raised the ADA, and it was obvious that after the fact, they did try some individual services for the parent as opposed to the group services, which didn't seem to work. The appellate court ruled in my favor but refused to address the issues. I think that they were worried about opening up a can of worms. It was a Rule 23, you'll never find it. The last name of the parents was Allen, I remember that. But they were hesitant to address the ADA issue.
See, I think everything with this.
And also, I would add that the next Illinois Parents Attorney Network training, the one that's coming up in the fall, is going to be on working with parents with mental health issues in child welfare. So that could also bring some expertise to answer your question as well. Any other questions that folks have? If not, I think Kent would like to make a comment, and then we'll do some thank yous.
Thank you all very much to the speakers. Thank you very much, gentlemen, for trucking over here and spending the time and investing the time in preparing. My name is Kent Dean. I'm visiting you all from Cook County. Myself, along with Lewis and Diane Redley from Family Defense Center and a few other people, got together in 2012. I think I was in the second meeting. I don't think I'm certainly not claiming to be one of the originators of this, but there was a recognition that some of the questions have touched on that. You know, parents attorneys, we don't have institutional basic knowledge. We're not in the committees. We don't get invited to the judges' meetings. Okay? That's what IPAN, Illinois Parent Attorney Network, that's what we're trying to correct. We're trying to fill that gap. And since 2012, I think we've been doing a pretty good job of it. This is our 6th presentation. I've attended every single one. I know my practice has improved tremendously. And I do a lot of this. This is primarily what I do. With that, thank you all for attending. And again, if you want to get involved, you want to get involved in the steering committee, you want to contribute in some way, we're not exactly, when I say contribute, we're not exactly, we don't have a budget or anything. It's just people volunteer their time and make their contributions in whatever way. If you're interested, by all means, feel free to drop me an email. I'm easy to find. Just Google, find my office, Kent Dean, D-E-A-N. My email is K-D-E-A-N, standard first initial last name, Kent Dean at kentdeanlaw.com. You can also reach out to the Family Defense Center. Again, they're easily found online. Just Google them, Family Defense Center. And they have a very expansive website. And there are some, if you're not familiar with them, there are some manuals on their website for indicated appeal hearings, etc. Quite useful and very comprehensive. As far as there was a question about ISBA, by all means, please do. I'm familiar with the ISBA Committee on Juvenile Law, and it's primarily state's attorneys, GALs, DCFS people. There needs to be more parents.
Is there a juvenile law? I just
Yes,
saw
there is.
family law or child law.
Yeah, there's a child law section, yeah.
Okay.
I know in Cook County, the Chicago Bar Association, we have a committee on juvenile law, which primarily deals with abuse and neglect, and that membership is primarily bar attorneys and people who practice at the juvenile court complex. But yeah, if anyone's interested in getting involved with the Illinois State Bar Association's committee, I do encourage it. We really need better representation in that committee. In the meantime, please, if you did not pick one up, please pick up an evaluation. It's part of our requirements for our MCLE, the expectations for MCLE. Give me your evaluation. I will give you a certificate for attending today. For people that are attending on the web, be sure to complete the application that you've been provided. And once we get that confirmation, I will then turn around and either email you or mail you your certificates. Presenters, talk to me later. I have one question to the people here. Those of you that have faced, those of you guys are downstate, I don't get an opportunity to ask people, a large group of downstate practitioners in this field, is ground M, failure to make progress in 9 months, generally the primary basis for termination for you guys as well?
Yes. In our county, they've been starting to file in more interest, concern,
Responsibility.
and responsibility.
Okay. Yeah, M does still seem to be the primary reason
80+% of the time.
statewide. Okay. There was talk about Gs earlier. I have heard some talk, there's been more Gs, at least in the northern district, but I hear that Gs have been used downstate regularly in the past. We don't see it too much in Cook County. Okay, thank you so much. Appreciate it.
Thanks to everybody who came. As I said, be on the lookout for the next Illinois Parent Attorney Network training in the fall. And thank you to our presenters especially who gave of their time and traveled here to be with us today.
Thank you for staying awake.